May I have your lordship's kind leave to mention 4 applications for inclusion in the list?
Applications under
And-
MSCC.
No,
Water
first
activity?
appeal and second appeal.
Yes.
And my lord, 1 second appeal for hearing.
Hearing means it will be taken up in the next month, not in this month.
Grateful. I'm handing over all the slips.
Your Lordship, may I be permitted to mention for inclusion? The matter was already fixed by Your Lordship on today's date, but it is not appearing in the list.
Is it a hearing matter?
Yeah, yes, Your Lordship.
Claim case?
Yes,
Oh.
Your Lordship.
Okay, give the slip.
Obliged, Your Lordship. Your Lordship, also one thing to mention, that is, Your Lordship was pleased enough to grant.
So another thing, if it is a hearing matter, let it appear as to be mentioned. Let it go to Lok Adalat. Thereafter, if it is not settled, I'll take it up in the month of January. Yes, file. If the file is yes.
In this matter, it's my appeal. One application is pending.
Yes.
That application has to be disposed of first.
No.
Substitution, attainment of majority application.
Okay, let it appear under the heading application.
So she is just mentioning so that it appears.
No, I thought it is ready for hearing matter. Okay, let it appear under the heading application.
Obliged, Your Lordship. Grateful.
May I be allowed to answer 3 matters in respect of claim case loss?
3 matters ready for hearing.
1 matter under heading hearing and 2 matters section 5 application loss.
Okay, so give that section 5 application to appear under the heading section 5. The other one ready for hearing, let it appear as to be mentioned. It will go to Lok Adalat. Thereafter, in the month of January, if it is settled, well and good. Otherwise, it will be taken up. Yes. যেটা hearing matter আছে ওটাকে to be mentioned দিয়ে দেবেন.
Well, if this appeal, my client has preferred an appeal for enhancement of the award.
2008 matter.
2008 paperwork are ready, my lord. I'm filing the paperwork. My bag has not yet been reached.
No, you have waited for the last 17, 18 years. Okay. So you wait for another 15, 20 days. Let it go to the Lok Adalat, then month of January.
Lok Adalat, it cannot be settled.
Very well, I'll take it up if it is not settled.
Your Lordship kindly fix the matter, my lord.
I'll fix it in the month of January, but prior to that, you pass through that Lok Adalat.
Your Lordship kindly pass the order. Today I am filing the paper.
Yes, record an order. Learned advocate for the appellant is present. It is submitted by the learned advocate for the appellant that the matter is ready for hearing. Paper books? And the paper books?
Paper books are being filed today.
And the paper books will be filed in courts of the and the paper books will be filed in courts of the day.
I'm filing paper.
As this is a motor accident claim case and may be settled through the Lok Adalat.
It is not settled because today is the last.
So who is appearing for the opposite party?
Gopalas Mukerjee. I have talked to yesterday night. She is willing to do the matter before your loss. Kindly fix the matter in January.
No, what is the difficulty to take a chance of settlement?
There are a lot of difficulties settle the matter before the insurance company. We shall go.
So there are so many matters which are being settled.
No, my lord, we shall go to the insurance office and my lord give the papers. They will think over the matter. Then they call. Then thereafter I shall go again. My lord, the matter has been settled. Thereafter they engage the lawyer. Lawyers who demanded the papers. It will be long process. It cannot be.
No, you see, before January, I cannot take it up. Okay.
January, your lordship kindly.
So that is why I was suggesting. Okay, let this matter appear in the month of January, second week of January.
The paper book, today I am filing paper.
The paper books filed be kept with the record.
Yes. Yes, my lord. My lord, your lordship kindly see the last order. While his lordship, the Honorable Justice Honorable Bandyopadhyay My lord, call for the lower court record. Lower court record has reached. My lord, it is a case of.
Yes, Mr. Singh, you are appearing.
My lord,
Is there any chance of settlement?
No, because.
No,
My lord,
let him take instructions.
My lord,
It is he who can say.
my lord, it is a case, my lord, dishonor of check. My lord, the award was passed against the owner. We have come here, my lord, that the casting of liability upon the my lord, insurance company, and insurance company will recover the amount. And my lord, the review application is my lord modified. First, the award was passed against the insurance company.
Okay, these applications are to be taken up. Can 1 and can 2.
No, can 1 and 2 dispose of.
Okay, record and order.
Kindly fix the matter on 16.
Learned advocates for the parties are present. As this matter is ready for hearing and the paper books have been filed, let this matter appear on
8 January.
My lord has already fixed up at least 50 matters in the first week of January. So your lordship will kindly take note
No,
of
those matters are report from Lok Adalat, not hearing. Only if it is settled through the Lok Adalat, very well the matter will be disposed.
My lord, last week my lord is
That is only report from the Lok Adalat.
in the last week my lord is fixing the Lok Adalat report. Prior to that, your lordship has fixed a large number of matters.
No.
At present, I am not fixing any matter for hearing, but only
My lord,
sent to Lok Adalat.
Unless your lordship give the date, my lord, for fixing.
Okay, let this matter appear on 8 of the 9/1/2026.
I'm grateful to your lordship.
Alert 4, I beg to appeal for the plaintiff appellant. Alert, in an appeal from appellate decree.
So,
Not
whose
an
applications is this? Can
Not-
3?
Application for appropriate order. Application for
Can 2?
appropriate order. Can 2, my lord, was subject to correction. No, Can 2 was pending. That is for additional evidence. That was to be taken.
That was already decided.
No.
That it will be decided.
It will be taken up along with the hearing of the appeal.
So, let it be fixed for hearing next month.
Yes.
My lord, an application can 5 is also there. If your lordship kindly comes to the order dated 19th June 2025.
Record.
I filed the ABB in opposition against the my lord. Appropriate order. Reply. My lordship has fixed the matter as an application after.
And if your lordship should desire a short point involved in
What
the
is this Can 5 for?
Can 3 though.
Can 3.
Oh,
Can 5
this is the prayer to condone the delay in preferring the application for substitution.
My lord, Can 4 and Can 5 was disposed.
4 and 5 is
5,
disposed.
5, yes, my lord. 4 is for substitution
5
and
5 is
for
condonation of delay.
condonation of
So,
delay.
those are disposed.
4 and 5 is disposed.
Very well. So, let this matter appear.
Can 3,
Can 3?
Can 3 is pending.
Yes.
That is an application for appropriate order.
So, what orders have you sought?
My lord, for implementation of the order of status quo. What happened? There is an order of injunction in the nature of status quo, which has been flouted. It is my contention. It has been flouted by my learned client, and we wanted, my lord, a direction to the officer in charge to ensure that the order of status quo is maintained.
Previous
That-
order was passed.
That is, my lord, sum and substance of my
So,
application.
that application is to be heard out.
My lord,
Yes,
that, my lord,
that-
affidavits were
shut up.
complete.
So, Can 3 application, these affidavits are complete.
My lord, this is my reply and
Actually, my lord, suit was filed by the plaintiff. Suit was dismissed. Appeal dismissed. They filed an order 41 application before their lordships and when their lordships, please to admit that we are the patta holders. There are other suit.
Who are, what is the interim order passed?
Interior parties are directed to maintain status.
Yes.
with regard to their positions.
But my lord, they are the outsiders. They are not the plaintiff, but the one other case, they shoot the dig against the state. Khotian
So,
different.
the appellant before this court is one of the parties in the suit.
One of the parties of the
That's why he's the plaintiff.
plaintiff. But
So, the appellant before this court was the plaintiff in the trial court.
yes, the alcohol and
So, at present, the appellant has come being agreed by the orders. Now, there is a direction by the division bench to maintain status quo.
yes.
So, your learned friend has a grievance that status quo is violated. So, let me see what is the violation.
Yes. An application which was filed, an appropriate order.
Let me see that. Yes, record an order. So, I'm keeping this application. for hearing.
Yes, my lord.
Learned advocates for the parties are present. Let this application CAN 3 of 2025 appear under the heading application on 8/12/2025. I'm keeping it on Monday,
My lord, 8, my lord, I have some difficulty. Any other date, my lord, subject. my lord.
9/12/2025.
Great.
View একটা view.
Lordship, I am for the appellant on behalf of my senior advocate Shima Ghosh.
So the matter is ready for hearing.
Yes,
So paper books have been filed.
yes, already filed.
So let it appear for hearing next month.
As your lordship.
Yes, record an order. Learned advocates for the parties are present. As this matter is ready for hearing and the paper books have been filed, let this matter appear for hearing on 9/1/2026.
Next. Item number 6, I am paying not today, my lord. The correction is there, Mr. Amitra could not attend.
Okay, not today.
My lord.
7, my lord, I am appealing on behalf of the caveator. My lord, the admission has not yet been made, my lord. Probably the court has
Is there any application pending?
no, my lord.
Who is appearing for the appellant?
I am for the caveator.
No, there must be some advocate appearing for the appellant.
Yes.
By whom?
Why it is appearing? Because it is the division benc's matter, my lord. Order 41 has not yet been.
Okay, I'm making it not today.
Then, my lord, kindly fix it on Monday because
Okay, not this week, but you try to ascertain who is appearing and intimate.
I have not mentioned the matter, my lord.
Okay, not today.
I am for the appellant in it. Well, this appeal was prepared by the insurance company. My lord, your lordship kindly grant my lord to file the the informal paper book which has been served upon my learned friend. The point involved. My lord, the point involved in this appeal by the insurance company has been taken is my lord, the driver had no driving license, so can recover. Another point is my lord, there are five payments, 40,000 my lord paid in consultory arm has been given 40,000 as per the Supreme Court decisions. That was considered by your lordship my lord, in my one judgment, which was delivered my lord, is my lord, that point was taken. This is the
Now,
crux
is
of
there
the
any
matter.
chance of settlement?
No.
No, let your learned friend take
My lord, the
instructions.
Lok Adalat, my lord, pay and recover order will not pass because the owner is recover. So your lordship kindly fix the
So
matter.
pay
You
and
take it
recover order was not passed.
not passed by the Lok Adalat. So my lord, let the matter, let the
Yes,
appeal.
record an order. Learned advocates for the parties are present. As this matter is ready for hearing and paper books are already filed.
Now, today I am filing the
The
paper.
matter is ready for hearing. Let this matter appear on 9/1/2026. The paper books filed in court today be kept with the record.
I am grateful to you. Yes, 10 mileage, same order be passed as per as with regard to item number 9, paper book 5.
আচ্ছা আইটেম নাম্বার 9 এ যে অর্ডারটা হয়েছে না ওইটাই করে দেবেন।
এইটা দিয়ে paper book 5.
Oh, other thing is this, is there any chance of settlement?
No.
Okay, then month of January.
Nine.
Same.
No, yeah.
And 11, my lord, I am for the petitioner. My lord, here the my lord order was passed on 27th November 2025. There is a correction, my lord, in the second paragraph. It was written as complaint case number 84. My lord, it would be 85. In the first paragraph, my lord, it is written as complaint case number 85.
It's
And
84.
It would be 85.
85 is there, complaint case number 85.
My lord, second paragraph.
Okay,
Second paragraph, 1,
paragraph.
2, 3, 4, 5, 6. Sixth line from the first.
Yes, complaint case number 85 of 2019. It is written there.
My lord,
Which paragraph you are relying? In first paragraph, it is written.
my lord, this is the proposed correction. My lord, that part would be corrected. Underline করেছি 84 যেটা আছে ওটা 85.
Okay. No, but in my order, it is reflecting complaint case number 85. There were there two cases or only one case?
Two cases, my lord. This is
Yes,
CRR 4061
Okay,
of 2025.
And there is there any other case?
Yes, my lord, two cases.
Okay, in one of the case, it is appearing, you see, as per the cause title, just a minute. As per the cause title in this 4061, it is complaint case number 85 of 2019. So, it is written as 85 of 2019. You go through this order, ওটা কি করে তাহলে 84 টা অন্য কোন অর্ডার থেকে এসেছে তাহলে? দেখো তো 4061 of 2025 ওটা। হ্যাঁ?
এইটাতে ভুল এসছে 4061 যেটা সেইটাতে অর্ডারটা এরকম এসছে আমি একবার অনলাইনে চেক করে
কি আছে এটা? আর নিচে নিচের 84 হয়ে গেছে এটাতে
এই যে কমপ্লেইন কেস নাম্বার 85 এখানে 84 এর
এটাই তো ব্যাপার যে 84 টা এলো কি অন্য নো কোয়েশ্চন
ঠিক আছে 85 অফ
85 of 2019 হবে
কিন্তু অর্ডার শিটে তো ঠিক আছে
হ্যাঁ না আমি বলবো ইঞ্জিনিয়ার দুটো কেস আছে নাকি 85 অর্ডার শিটেও 85 আছে
এই সার্ভারটা দেখা করতে
খুঁজছি না 84 লেখা আছে উপরে যেখানে এ থাকে, হ্যাঁ উপরে যেখানে 85 লেখা আছে সেটা ঠিক আছে, নিচে 4061 4061 এর
অর্ডার শিটে আছে 85
লেখা আছে 80 যে কপি আছে সেখানে আছে 84, ঠিক আছে ওটা তারপরে ভুল আছে।
You see the case record, okay? Whether you see in the cost title what is there, then only it will tally. দুটো analogous case থাকলে অনেক
In
সময়
the cause title, this is written as 85 of 2029, 2019, sorry.
85 of 2019 in the
85.
cost title.
Yes, my lord.
So that has to be done.
Yes, my lord.
And in the order sheet, you see what is there.
In the order sheet, my lord, in the first paragraph, it was written as 85. And my lord,
There in the order sheet.
my lord, in this order, my lord, this is written as 85. My lord, the order I have,
The server copy of the order.
in the server copy, my lord, it is written as 84.
তাহলে as per the order sheet, it has to be corrected. Server copy has to be corrected.
Yes, my lord.
এটি অর্ডার করতে হবে তো নাকি এটা আচ্ছা server to be corrected. Yes. Learned advocate for the petitioner is present. The matter is put up for necessary rectification. In terms of order dated 27/11/2025, the learned judicial magistrate 6th Court Howrah was requested to dispose complaint case number 85 of 2019 very expeditiously. But in the server copy, there is a mistake which shows that complaint case number 84 of 2019. Let the server copy be corrected as per the order sheet dated 27/11/2025.
Deeply obliged.
Yes, other contents remain unaltered. Yes.
দাদা আমি কি ওই অর্ডার থেকে একটা কারেকশনটা করে দেবো নাকি ওটা থাকবে? ঠিক আছে ঠিক আছে।
12 and 13.
My lord, this is an insurer's appeal along with the cross objection of the claimant.
Last year, I am praying for pass over last year.
Okay, pass over.
Martin.
Yeah, please, Your Worship. For the respondent.
Whose applications are this? Can one
is yeah. Can one is disposed. Substitution application was filed.
and then can two?
Can 2 is mine for vacating the stay.
Okay. This is in connection with which case? First appeal. Let me see the order.
This is a miscellaneous appeal. Eviction suit was filed before the junior judge Shialda. He dismissed the application under order 12 rule 2 because the property belongs to a Thika tenant.
So against that order,
Against that
appeal was preferred.
appeal was preferred. Appeal we have succeeded, and then the tenant appellant approached this.
No, in the appeal, the matter was remitted back to the
Yeah.
learned trial court.
Yes, Your Lordship.
So against that, they have come.
Against that,
The respondents have come.
defendant
The respondents,
defendant's appellant.
yes, defendant has come against that order. So
There is a order of
So the-
stay,
you are
and they are
the-
enjoying stay for
now
last
you
8 years.
you are the appellant.
I am the respondent here.
Oh, you are the plaintiff respondent.
I am the plaintiff respondent.
So this is an application for vacating.
This is an application for
Anyway,
vacating.
you see,
They are enjoying stay for last 8 years.
Stay of all further proceedings.
Proceedings.
Anyway, you see, unless the other side
There,
is.
there is an order dated 10/10/23. There is an order.
You are appearing for?
Lordship, the advocate under the petition is on the way. Kindly passes it off.
Okay, not today then.
Not today.
Hey, Rajesh, eternally achieve. My lord, this appeal preferred by my client against an award of dismissal by the tribunal. My lord, the lower court record has reached to this honorable court. My lord, I pay 4 weeks time. My lord, to file. Can achi. Can in fact, so your lordship kindly grant my lord 4 weeks time
To file the paper books.
to file the paper book and fix the matter.
And service upon the respondents is complete.
Is because Mr. Rajesh Singh appears for the insurance company.
It is not in my entry.
এই তো রাজেশ সিং
আমার লেখা থাকলে হবে হবে
আছে অর্ডারটার মধ্যে আছে
But your lordship is fixing the matter after 4 weeks. Not I'll
So
ask
if you are appearing,
lordship. But if no, then lordship keep it up for tomorrow. Not all the day.
No, my lord. Your lordship kindly grant 4 weeks time to obtain the some part
No,
of the lower court record.
no, are you convinced that service is complete?
Yes, service is complete.
Yes, record and order. Learned advocate for the appellant is present. Learned advocate for the appellant press for time to file the paper books. Let the paper books be filed within 1 week after vacation.
Within my lord, within 2 weeks, my lord.
Within 2 weeks after vacation.
Within 1 week after vacation.
Okay, within 1 week after vacation, liberty to mention.
And my lord, your lordship asks your court officer to send down the lower court record because my lord.
Yes, let the lower court's records be sent down to the department to obtain certified copy.
I'm grateful. And my lord, can you fix the matter on 16 January?
No, you mention. After you get ready, you mention.
What is 16?
My lord, in this matter, paper book have been filed. My lord, there are 2 insurance company, 2 victims involved. This is a case of a my lord, the minor victim who suffered my lord disability to the extent of 60%. He become my lord disability both in my lord mouth and my lord the hearing. It my lord, my grounds are my lord, it amounts to 100%. Already 16 lakh was awarded. My client has come for enhancement of that award because the other parts of non-pecuniary damages are my lord, not only medical expenses and my lord treatments, my lord the expenses given. Now my lord, no loss of earning, no my lord
So
assessment.
paper books have been filed.
Paper book have been filed.
So it will
My
be taken
lord,
up in the month of January. So can 3 any application is pending?
application for taking my lord, the disability certificate. That was my lord, that will be my lord taken my lord at the time of final hearing.
No, whose application is this? Can
My application.
take up the disability certificate?
Yes. Because my lord, on the date of disposal, disability certificate was not obtained. After that, my client, my lord, in this my lord case, my lord, both my lord, the minor's victim, father died. The grandfather is only the legal guardian or court appointed guardian. So, my lord, the claim case was conducted by the my lord, the grandfather of the minor child. 16 lakh was granted. My lord, he became my lord the 100% disability, but the board says
Anyway, paper books are ready.
paper books
Let
filed.
let it appear for hearing in the month of January.
And my lord, can will be disposed of at the time of final hearing.
Yes, learned
Because
advocates for the parties are
Supreme
present.
Court says,
Yes,
my lord, Supreme Court says, my lord, the
Yes.
interrogatory application for disability cannot be discarded, even at the appellate stage.
Okay.
I have got the
learned advocates for the parties are present. As this matter is ready for hearing and the paper books have been filed, let it appear for hearing on 9/1/2000.
9 is Friday, my lord. Friday.
9/1.
My lord, 9 is, my lord, or 12, your lordship.
Okay,
will be-
12/1/2026.
Yes, I'm grateful.
No, no.
আমি কিছু জানি না সবাই যেটা যেটা পায় সেটা ধরে দেয়, যেটা পায় না
আমি কি এখানে নিমিত্ত মাত্র।
18 Lordship, in this matter, we for the appellant Lordship, there was a direction for stay till disposal of the application. Kindly Lordship, call for the Lordship lower court record such that we can Lordship prepare the paper book and fix Lordship for hearing. Also, we can.
Is it a claim case?
No, Lordship. This is a Lordship arising out of a remand matter. So,
Okay,
Lordship.
okay. So matter is ready for hearing.
No, Lordship, we have to prepare the paper book, Lordship.
So trial court's records are necessary.
Yes. We can Lordship prepare informal paper book, Lordship. Kindly direct, we will prepare and Lordship serve copy upon the opposite party.
Given opportunity to file an opposition against their application.
Application is for?
Application for stay. Kindly consider Lordship the last order, Lordship on 18 February
In
2025.
order, interim order is continuing.
Till disposal upon hearing. So Lordship, it is not objection.
Disposal means that application.
It
till
is not
disposal of the
necessary.
application.
It's a matter of record, Lordship, on the basis of trial court record, Lordship, your Lordship will heard the matter.
But
So Lordship, at this stage,
Section 5 was condoned.
yes, yes,
Thereafter, the interim order is continuing now.
yes, Lordship.
Application is pending, given opportunity to file an opposition against the application.
Opposition, this is a civil matter, Lordship. So they cannot improve their
They
case,
are
Lordship,
offering interim order of injunction,
without the
not
evidence and
interim.
stay, Lordship.
That service and we are appearing.
Yes, record and order. Learned advocates for the parties are present. Learned advocate for the appellant is pressed for time to file the informal paper books. Thus, the informal paper books may be filed within 1 week after vacation.
Lordship, after
Yes.
2 weeks, Lordship.
Within 2 weeks after vacation, liberty to mention. The affidavit in opposition may be filed to can 2.
Can 1, Lordship.
Can 1. No, can 1 is disposed.
Yes, yes. Can 1 is a section 5.
Yes, can 2.
Can 2, Lordship, for condonation. Can 1 for Lordship stay.
Okay, can 1 of 2024. The interim order that is already
Already
continuing.
there, Lordship, stay till disposal of the application.
File to can 1 of 2024 as well as reply in the meantime.
Reply, Lordship, we prepare the paper book, Lordship. Whether opposition is required, Lordship. Kindly consider the entire, Lordship, exhibit.
Okay, at least let him file the opposition.
Opposition, Lordship.
1 week after vacation.
Yes. As the interim order is to continue till disposal of this application, no further order is necessary.
Grateful, Lordship.
But we are responding number 1 and 2.
Upon rest, Lordship, it has been dispensed.
Okay.
Already dispensed by the way.
Learned advocate for the appellant and learned advocate for respondent number 1 and 2 are present.
But the lower court record be called for.
No, is there any direction to call for the lower court
No,
record?
there was no direction. Your Lordship can call for the lower court record.
Okay, the
Then,
trial
Lordship,
court
the
record
filing
will
of
be
the
called for.
then the filing of the paper book will be delayed, Lordship, unless the paper book is, Lordship, arrived.
No, I have granted you opportunity to file informal paper books. In the meantime, I have called for the trial court record.
As your Lordship, please.
Okay.
Grateful.
Nineteen, I am appearing on behalf of the appellant insurance company.
Appearing for the claimant responded, Lordship, application for subscription. The appellant.
Can 2.
Can 2, Lordship.
Yes, show the record.
Appellant, sole appellant, Lordship.
Let me. So, COT is your application.
Lordship. Court.
Okay, the sole respondent, oh, the respondent number 1 and 2. Oh, respondent, there was only one respondent. That is, yes, yes. When did he die?
Died 20, kindly see page 8, Lordship, death certificate.
Page 8. Okay, 22/4
He died on
2025.
22 April 2025, Lordship.
Okay. Yes, record and order. Learned advocates for the parties are present. The application for substitution, Can 2 of 2025, is taken up for consideration. Its application is taken out for substituting the name of respondent number 1, Shudyendu Bikas Jana, on account of his death. Stop. The respondent number 1 in FMA 1486 of 2024 died on 22/4/2025. Stop. The delay, the grounds for delay is sufficient. Thus the delay is condoned and the prayer for substitution is allowed. Let the name of Shudyendu Bikas Jana be deleted from the cause title and the name of the legal heirs being the applicants, namely Suchitra Jana, Satyajit Jana, and Sravani Jana, be substituted in his place and stead. Similarly, COT 20 of 2025 be amended accordingly. The department to carry out the necessary amendments within 2 weeks. Liberty to mention. Can 2 is disposed.
Twenty-one, I am appearing on behalf of the appellant insurance company, my lord. It's appearing for the first time. I've deposited the statutory amount of 25,000. This is the photocopy of the challan.
Yes, record and order. Learned advocate for the appellant is present. Stop, as the appellant insurance company has deposited the statutory amount of rupees 25,000. There shall be a stay of the judgment and award dated 10th day of June 2025, passed by Learned Additional District Judge, Second Court, Tomluk, Purbo Medinipur, in MSC case number 276 of 2018 for a period of 5 weeks from date. Stop. The appellant insurance company shall take steps to deposit the entire awarded sum within this period of 5 weeks, along with interest awarded by the Learned Tribunal, by the Learned Trial Court, from the date of filing of the claim case till date of deposit, and the same shall exclude the statutory amount. Stop. In the event the entire awarded sum is deposited within the period of 5 weeks, the interim order of stay shall continue till disposal of this application. Liberty to mention.
And my lord has given the order for investment.
Yeah. The Registrar General High Court Calcutta is requested to invest the amount deposited in a fixed deposit of a nationalized bank and renew the same from time to time.
Only one humble prayer, my lord. In this matter, 6% was directed to be, the interest was at the rate of 6% per annum, and there is also one default clause, my lord. That is also 6%. Only if my lord mentions that, wherein my lord had stated that with interest, as per the order of tribunal, at the rate of 6%.
No,
there is one default clause also.
Default clauses?
Default clauses, if it is not satisfied within 90 days along with 6% interest, then claimants can put it for execution along with further 6% interest.
So execution and the claimants can claim further interest.
Yes, 6%
Not
and
only
6%.
Only this thing.
Only 6% if my lord just clarifies.
It is hereby clarified that the amount of interest which the appellant is to pay is from the date of at the rate of 6% only from the date of filing of the claim case till the date of the deposit, without prejudice to the rights of the parties.
I'm extremely grateful, my lord. And I'm sorry, my lord will also refer this matter to the Lok Adalat.
But you see, other side is not here.
Oh, I have spoken to him.
Oh, the other side has entered appearance.
Yes.
As this is a motor accident claim case and the matter can be settled through the Lok Adalat, the matter is referred to the National Lok Adalat to be held in the month of December.
I'm grateful, man.
Fixed 9/1/2026 for report of the National Lok Adalat.
Grateful, my lord. 22, I am appearing on behalf of the appellant insurance company. This is coming up for the first time, my lord. This is the copy of the statutory deposit challan. I have made one mistake.
Yes.
This matter is to be sent to the Lok Adalat. I just, since they are all one by one, they are coming. This matter is to be sent to the.
So both the matters.
No, I'm sorry, I just.
The other matter cannot be sent. The other matter respondent has not appeared. তাহলে ওটা কেটে দিন লোক আদালত যেটা লিখেছি
This I've spoken.
এটাতে লিখুন learned advocate for the appellant is present as the appellant insurance company has deposited the statutory amount of ₹25,000. There shall be an ad interim order of stay of the judgment and award dated 31st day of July 2025 passed by the learned additional district learned judge bench 5 City Civil Court Calcutta in MSC case number 518 of 2019 for a period of 5 weeks from date. Stop. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as awarded by the tribunal from the date of filing of the claim case till the date of deposit, which shall exclude the statutory amount. Stop. In the event the entire awarded sum is deposited within the period of 5 weeks, the interim order of stay shall continue till disposal of this application. Stop. As this is a motor accident claim case and both the respondents claimants have already appeared.
Yes.
And there is a chance of settlement. The matter is referred to the National Lok Adalat to be held in the month of December. Fixed 9/1/2026 for report of the National Lok Adalat.
My lord.
তাহলে আগেরটাতে 9/1/2026 ওটা কেটে দেবেন, just liberty to mention.
My lord, I'm deeply obliged.
Well, I do not learn it. I am for respondent, Mr. Amitan Rai. He is not. I'm not paying talk to them.
My lord, I'm praying let the matter be taken up day after tomorrow, my lord, on 5th.
Okay, then not this week.
Not this week. My lord, I'm grateful.
Hey, 24, yes. Yes, here in the short point is involved.
Very short point. The entire case, claim case was dismissed by the learned tribunal at the threshold on the
What is this can 2 for?
Can 2 is the application for appropriate order without owner insisting.
Service upon all parties are complete?
Yes.
Yeah.
Insurance company is appeared.
No, the other vehicle owner.
Yes, sir, but your lordship knows that vehicle owner is not.
No, if it does not appear,
Yes, I have,
nothing
sir.
to do.
I have, sir. Everybody.
So condonation of delay application. This is
এই তো।
কি file করিস? So condonation of delay application.
No, that was condoned.
So can 2 is disposed.
Can 1 was the condonation or delay that was disposed. Can 2 is the application for appropriate order, saying that entire matter can be disposed of with these papers.
Okay, let me see the order impugned.
The memo, kindly see the memo.
মেমোটা নিয়ে নিয়েছে?
হ্যাঁ, দিয়ে দে ওটা তোমার কোম্পানিকে দিয়ে দিয়েছি অনেকদিন আগে।
এই দেখি এটা মেমোটা
এই
Okay. This 11/3/2025.
Yes,
Okay.
11th March 2021. Order number 27. Both the petition and the respondent insurance company are present at my file Hazira. Today is fixed for further hearing of the petition under Order 7 Rule 11 CPC filed by the respondent insurance company along with the written objection and petition section 5 of the Limitation Act filed by the petitioner. Peruse the petition. An objection recorded of the application under section 140, 166, 163 of the Motor Vehicle Act has been filed by the petitioner. But I am pausing for a very moment. Under the new act, there is no section 163A.
This was filed in which year?
It is filed in 2000.
23.
Yes, 23. 23. So after coming into the new act.
New act means new sections.
Yes. After repealing some provisions.
Some provision.
Yes. 163A was repealed. Instead, it was 164 was introduced.
So your case is 163 or
166.
166.
Yes.
Okay. Yes.
Now kindly.
Now which provision is repealed? Earlier, the delay.
Once kindly come 166.
Yes, 166.
Section.
Yes.
166. Kindly come section 166 subsection 3. No application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. That was introduced in the new act. Now I also draw your section subsection 4.
So this is 2019.
19 Act. This subsection was not in the earlier provision.
No, earlier act means.
Oh, 1988.
No, 2023. This was there in force. 2023.
Yes, that was after 19. So
this was. So this provision came into force in 2019. Okay.
It is effect from 2022 something.
To take effect from
22. No. Effect from
1/4/2022.
However,
incident took place in 2023.
Yes. So my case, new act will be applicable.
Yes.
And so section 166(3) is a bar under the
new act.
Yes.
Yes. Any power given to the tribunal to condone the delay? Earlier it was.
So for the 166. There is a 3. There is no such power.
No, 163. But you
now,
say
that's why I am coming. Court has considered that aspect. But only consider
Yes, earlier this limitation was not there.
No, there is no charge limitation. Now only question.
Yes.
Only question whether Section 5 application is at all applicable in the instant case. If it is my delay was only 10 days. My application for continuous delays. Now only question 166(3) can be overcome by filing a Section 5 of the Limitation Act. I am drawing your attention of kindly, if your lordship kindly consider the Section 29 of the Limitation Act. এই দেখ ইনফরমেশন নিয়ে চলে এসেছি
লিমিটেশন একটা দিন
ওইগুলি কোথায় আরো তো দুটো বই আছে এখানে
লিমিটেশন
ওই যে যখন আছে
এখানে নেই
রাজু আমার কোন ব্যাপারে তো লিমিটেশন একটা আছে কিনা একটা আছে জজকে মে আই রিড মিলট
আজকে বড়
দেখো ঘরে দেখো একটা কি আছে কিনা
কি দেখো কি দরকার
লিমিটেশন একটা
নেই
হয়তো আছে আছে আছে
yes 29(2)
ও থাকলে আমি একটু ফেলাচ্ছি দেখো তাহলে সেকশন 29 সাবসেকশন 2
yes
where any special or local law prescribe for any suit or appeal or application a period of limitation different from the period prescribed by the schedule. The provision of Section 3 shall apply as if such period, where the period prescribed by the schedule and for the purpose of determination any period of limitation prescribed for any suit, appeal, or application by any special or local law, the provision contained in Section 4 to 24, inclusive, shall apply only insofar as to the extent of which they are not expressly excluded by such special or local law.
Yes.
So, under the Motor Vehicle Act, there is no specific provision that Limitation Act will not applicable. There is no exclusion under the Limitation Act. In such section provision of Section 29, Section 5 of the Limitation Act will squarely applicable in the Limitation Motor Vehicle Act. And if the Section 5 application is applicable, then my application for condonation of delay of Section 5 application was dismissed without any reason, without any giving any explanation by the learned tribunal is bad, absolutely bad. This is my humble submission.
So let me see the order. The Act itself does not confer any power upon the tribunal to condone the delay.
On the contrary, this provision, there is no exclusion clause in the motor vehicle.
No, suppose the Act provides power to the tribunal, then it is not necessary to go for the Limitation Act.
In case of appeal 170, Section 173, there is a provision. The court can condone the delay even after filing of 90 days. But so far the Section 166(3), there is no such clause. On the contrary, 166(4), kindly consider that aspect also.
Yes.
After all, this is a beneficial piece of legislation. The whole object is to provide the compensation to the victim family.
Yes.
The Section 66 subclause 4, the claims tribunal shall treat any report of the accident forwarded to it under Section 159 as an application for compensation under this Act. So there is a contradictory provision. On the one hand, I have to come within 6 months. On the other hand, Section 4, subsection 4 of the 166 does not prescribe any period for filing the report by the tribunal. The main object to provide the compensation to the victim family. So I cannot thrust out from my getting the compensation in a piece of legislation, though I have suffered victimized by a motor vehicle being a third party, I cannot thrust out.
Just as you see, unlike this provision of appeal, in appeal,
yes there is a one.
The court has power to condone the delay.
Yes.
But so far this claim is concerned, this statute does not provide the power to condone the delay, but under the Limitation Act.
There is a for all special act. Then if the intention of the legislature was to exclude the persons, then they should have insert a provision.
Okay, what was the earlier provision in 166? Do you have the earlier provision? Let's compare the same.
Yes. And listen. The earlier clause 3 was not there. There's no limitation period. There's no limitation.
Yes, let me see. Yes, there was no such provision.
No such point. Now, since it is after all, this is an application for summary procedure. Tribunal should proceed in a summary way. Considering the entire aspects, in earlier decision of Supreme Court said, no single issue cannot be disposed of, particularly the maintainability point cannot be disposed of in a single manner. Entire issue should be disposed of the case, so that if there is a mistake on the part, the appellate authority can invoke the jurisdiction and correct the mistake. So in the instant case, only the maintainability point was disposed.
Certain decisions were also relied upon.
Yes.
In this case.
Well, I am placing some. Very recent Supreme Court also interfered in the matter in the writ proceedings, where the virus of the act probably challenged before the Supreme Court directed that no motor vehicle case would be dismissed on this ground. No tribunal should dismiss the motor vehicle case under the 166(3). That was the interim order passed by the Supreme Court. Now, I can consider this aspect of the also. Beamless and others versus New India Assurance Company, 2010, Volume 4, West Bengal Law Report, WBLR, SC 64.
Thank you.
Yes.
Here, the maintainability point was only considered and dismissed. Supreme Court, paragraph 6, Supreme Court demanded the entire case. The tribunal dismissed, the High Court also confirmed, the Supreme Court also turned down the
Yes, which paragraph?
Paragraph 6.
Yes.
And main issue, the appeal is partly allowed, the order dated passed by High Court as well as the order dated by the tribunal. The claim petition shall be decided by the claim tribunal after hearing the party in accordance with law.
So what was the subject matter there in that case?
Only the maintainability point was considered and a case was dismissed. Supreme Court says the only maintainability point cannot be decided at a time. Entire matter, all the issue should be decided since it is a summary procedure.
Now you see, the learned court has also dealt with some of the decisions, and the tribunal cannot condone the delay.
Five and six, my lord, if you allow me to place.
Yes.
Paragraph 5 and 6. The case of the claimants appears to be that the additional premium was paid by the insurer to cover the risks of the driver and the vehicle and the policy of the in persons of the classes persons entitled to drive includes the insurer and accordingly the insurance company is liable. On the other hand, the insurance company has denied the liability principally on the ground that the deceased being the owner of the vehicle is not a third party. Section 166 of the Act provides for an application for compensation arising out of an accident of the nature specified in Section 165(1) may be made inter alia by all or any of the legal preventive of the deceased where death of the resulted from the accident. Section 169 makes a provision that claims tribunal shall follow the summary procedure subject to any rules that may be made in this behalf. The Code of Civil Procedure Act 1908 is not applicable to the proceedings before the claims tribunal except the extent provided in subsection 2 of the section 169 of the rules. The whole object of the summary procedure to ensure the claim application is heard and decided by the claims tribunal expeditiously. The inquiry under section 168 and the summary procedure that claims tribunal has to follow do not contemplate the controversy arising out of the claim application being decided in piecemeal manner. The claims tribunal is required to dispose of all the issue one way and the other in one go while deciding the claim application. This is my case.
This is a question of fact, okay, that whether policy was renewed or not. And this is a case of, no. You see, question of fact cannot be decided without going into the evidence, and all issues are to be decided. So whether you have paid the premium or not, that is a question of fact. The court ought not to dismiss on the ground that you have not paid the premium. But this is a question of law, this point of limitation, okay?
That is also a question of facts and law.
That is a question of fact, okay? Whether you have paid your premium or not, that has to be decided on evidence.
The Limitation Act is that is a mixed question of fact and law.
Limitation Act, you see.
Mixed question of law and fact.
Because you see, from the date of the incident, how long? You filed beyond 6 months. How many days of delay?
10 days.
10 days of delay.
Now only question whether section 5 will be applicable or not.
Just a minute. Yes.
So now only question is whether section 5 will be applicable or not. In view of the court, neither tribunal also not consider the provision of section 29(2). This is a general. And on the basis of section 29, it is followed by Supreme Court in numerous decisions. even after 2016, I have got a decision of 1995, when the special law prescribed differs from the period from the Limitation Act, then provision of section 5 put to beneficial pay. After all, finally consider that this is a beneficial piece
Whether
of
according
legislation.
to you, this provision is mandatory or directory?
It should be directed. That can't be mandatory.
It should be directory.
Yes, that cannot be mandatory.
No, but you see the language of this provision. If it is directory,
section 29(2), that is mandatory. Because only concern last line. If there is no exclusion clause in the General Special Act, if the intention that no limitation act will be applicable, that provision should be inserted in the Motor Vehicle Act. Then no provision of limitation act will be applicable since it is a self-code. That is not there. Otherwise, section 29. Otherwise, I am entitled to get the compensation. Even I want to appear, make an application. After the getting of the information of the accident, the tribunal as well as the insurance company is liable to make payment. That is under the new scheme.
no, here in your claim petition itself, did you give any explanation? What is the delay?
Yes.
No, in your
yes.
in the petition itself, in
yes,
your claim
yes.
petition.
Yes.
Where is that order?
That was
no, not section 5. Suppose in your claim petition, is there any column regarding delay?
No, I filed a section 5 application.
Separate application you filed?
Yes. And Nale Tribunal not to pass a reason order. Why my section 5 application is dismissed? A judicial order must be with a reason order. Not single reason was given. They cited so many decisions, but not given any reason for dismissal.
Lord, you're also calling grant me one moment time, Lord. I'm coming in a minute.
Some of the High Court has passed in favor of the claimant, some of the but we are bound by the but they have never considered the provision of section 29(2) of the Limitation Act. Not a single judgment in the High Court. That's why they have pardoned.
Okay, you just do one thing. You consider this decision 1992 ACC 717. That is Mayor Ramdas Behanand Bhai
1992.
Yes. No, I1.
Yes.
Within bracket 1992. ACC.
SCC.
A, not SCC. Accident and claim cases. 717. Ask your learned friend.
717.
That is, cause title is Mayor Ramdas Behanand Bhai versus Harshad Bhai, Mala Bhai. Okay, the another is.
My lord will once again repeat the cause title.
Mayor Ramdas, MER, Mayor. Mayor Ramdas Behanand Bhai versus Harshad Bhai, Mala Bhai. Number I, within bracket 1992, ACC 717.
Yeah, that's one.
Then you also consider this.
At that time, there is a Not, under 1939 Act, there is a limitation act.
Then you see this one
And
also.
there is a provision of limitation 1 year with the scope of
No, no,
condonation
I
of
shall
the
consider. There is another thing. Vinod Gurudas Raikar versus National Insurance Company Limited. 2, that means 2I. The earlier one was 1I.
Yes.
This is 2I within bracket 1991 ACC 449 SC.
Yes, is also going to buy. Probably this is under 139 Act.
No, this is 1991.
91, but this is under 1939 Act.
Anyway, so these two are to be considered. The
But
principles laid down.
1939, my lord, there is a provision of
No,
limitation.
no, not 1939. In the old act.
Old Act is 39 Act. It is initially
Under the old provision.
under 39 was the initial act. It was subsequently 1988 Act. It was again amended in 1994. Then after 1994, it amended further in 2018 by notification. Even after notification, the entire act is some of the provision repeal and of the new act has come in 2019. And in the new act in 2019, this provision was.
Consider this one also. AIR 1996 Supreme Court 2155. The cause title is Dhandalal versus DP Vijay Vargia.
Your Lordship is finding these references, my lord, from my lord's own
From
noting.
the book citation, from the Motor Vehicle Act citation. So, let your learned friend consider these decisions.
Your Lordship stated, my lord, Dhannalal.
One is the last one is Dhandalal versus DP Vijay Vargia. AIR 1996 Supreme Court 2155.
1996 Supreme Court 2155.
And the other is Mayor Ramdas Behanand Bhai. Anyway, ask your junior that I have 1992 ACC 717.
Lordship.
So you consider this judgment. When shall I keep it? Monday?
My lord, before that, my lord, since, my lord, unfortunately, my lord, I did not have the copy of this award passed by the tribunal. My lord, my learned friend had given it to my client, insurer, but it was not forwarded to me. But my lord, I was going through this order passed by an impugned order against which my learned friend has preferred this appeal. My lord, this order, my lord, I find refers to, my lord, more than 24 High Court cases.
Okay, if you want, you can find
My
this
lord,
out also.
this is one part. And my lord, the submission of my learned friend is that this insertion of section 166(3), my lord, which was earlier not there. Earlier, my lord, there was no limitation. You could come up after the accident any point whenever it was to your liking. But my lord, Parliament in its wisdom, my lord, decided that no, this coming and going should not be allowed. My lord, they put in a specific cap. My learned friend's submission today is, my lord, that this specific cap, my lord, is redundant, is of no value, and my lord, is unnecessarily. The statute is there. And my lord, this on the ground of beneficial legislation, my lord, it says that no, it should be given a go by. A special statute is specifically, my lord, inserted. Parliament, knowingly that it was not there earlier, inserted this statute. And then, my lord, the submission being made that no, it is redundant, it is of no use or no value. My lord, this is one aspect your lordship has to look into. Secondly, my lord, Honorable Supreme Court, my lord, this last month, my lord, is in the session of this, my lord, for the last 1 year, my lord, this was inserted, my lord, in 1st April 2022 onwards. Limitation.
Yes.
My lord, thereafter, my lord, throughout the country, a number of cases, my lord, have been allowed without condonation. I'm referring to the High Courts, my lord.
No, but this condonation aspect was dealt with.
Yes, 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 yes.
After
Milord.
considering the provision
yes.
dealt with.
Yes, yes. Milord, I was just indicating to your lordship, Milord. This case also, Milord, my learned friend is stated that it has not been dealt with. I'll read out this award passed by the tribunal. This, Milord, your lordship will see it has been dealt with, Milord, specifically, and why this was not allowed. That has also been, the reason is there. Milord, different honorable high courts of the country, Milord, in some cases, without condonation of delay, Milord, they said that no, it is a beneficial legislation as he has submitted, Milord. So we will condone the delay after 6 months of filing. Some honorable high court said that no, we will not give a stateway without acceptance. You file a condonation. Some high courts allowed this delay with condonation, in spite of this bar being there. And Milord, some high courts said that no, when a specific statute has been there, the virus, Milord, is not been, Milord, Supreme Court has not said anything as yet. So, Milord, they said that no, we will dismiss after 6 months from the date of accident. Learned Tribunal, Milord, in this particular case, has taken note of everything, and then Milord came to a finding because of Himachal Pradesh's judgment, and Milord one Chennai judgment, Milord, Madhya Pradesh judgment. Milord, they said that Learned Tribunal said that no, these two judgments are already there. Himachal Pradesh, Milord, has rather given reference to Milord 24 other cases of different high courts, Milord, that no, this section 5.
Anyway, you just go through them and come on Monday.
Now, Milord, the last part, Milord, I'll also show your lordship, Milord, the Supreme Court is in the session of the matter.
Very well.
Supreme Court has said, Milord, it has also passed an order.
Very well. Whatever orders we pass, it will abide by the result or order of the Supreme Court.
Milord, Supreme Court, Milord, has said that during the pendency of this.
Is there any stay of further proceedings on this issue?
No,
by the
Milord,
Supreme Court?
Milord, Supreme Court has said that when we have taken note of this and we are in the session of these cases because this is creating trouble throughout the country. So in between, now onwards, that is the order of 4th of November last month, Milord, is not even a month today, that during the pendency of this, no further, Milord, claim applications should be dismissed on the ground of limitation. But this is prior to that.
That is an interim order.
That is an interim order, Milords. But Milord, in this case, it has already been dismissed.
Anyway, this
Milord, we will
is a
come back.
continuation of the proceedings.
Lordship. So, Milord, we will come back with those to your Lordship, Milord. Your Lordship will
I'm keeping it on Monday.
No, Milord, at least 1 week. Or Milord, or after vacation.
No, after vacation.
Milord, because I'll tell your Lordship, Milord, this award, Milord, which is annexed to the memorandum, Milord, it was not read out. Milord, it refers to at least 26 judgments. I do not know if that is correct.
Whatever it is, you go through the relevant judgments and you.
Milord, relevant judgments we will go through, Milord. So that is why, Milord, 7 days time.
There may be several judgments in this field, okay?
Yes.
Several thousands of judgments you have come across.
Milord, the references
but
which
all
have been
judgments
given,
can't be gone.
No, Milord, there won't be thousands of judgments because, Milord, this is only after, Milord.
MSCC, this motor accident claim,
Milord,
you have come across thousands of judgments.
Lordship. But the issue involved here would not be having thousands of judgments because this issue has, Milord, germinated after 1st April 2022, not prior to that. So, Milord, we will be only dealing with those cases. Milord, I'll get these references which is referred here in this award of the
Shall I
tribunal.
keep it next Thursday, next Wednesday?
Next Wednesday or Thursday, Milord, we'll get ready.
Yes,
by that.
record an order. Learned advocates for the parties are present. Heard learned advocates.
Section 29.
Let this matter
What are against?
appear on (10) 12/2025
10/12, Milord.
under the same heading.
Under the same heading. I am grateful to your Lordship.
Section. এই নামটা দিই।
এটা আমি নিয়ে নিয়েছি এবার তো নিয়ে নেবো
দাও ওটা দাও
এখনো দেবে না
আরে জেরক্স দিয়ে দিচ্ছি তুমি চাই তো এটা তোমাকে
হ্যাঁ সবই চাই যেটা যেটা
সব দিয়ে দিচ্ছি।
জাজমেন্টের কপিটা হচ্ছে
এই পুরো ফাইল ধরে দিয়ে দিচ্ছি
আর
তুমি সেকশন 29
হ্যাঁ
সেকশন 29
পিটিশনের নাম দিলাম তো না
আচ্ছা ঠিক আছে তাহলে এটা জিজ্ঞেস করে নিন
অ্যাপিলেন্ট হ্যাঁ
বলতে না
আগে যে ছিলেন দিয়ে পেয়েছেন
কি করবে
নিয়ে নেবো
আরেকবার দিয়ে দেন
জিজ্ঞেস করলে ওর বলবে যে জিজ্ঞেস না হবে
আমি কি করছি
ওবলাস্ট
তো বাবার কাছে ছিল না
I'm for the opposite party, my lord. Previous occasion, they have prayed for time to file reply to the opposition filed by the opposite party against the application under section 5 of the Limitation Act. But they have not served any reply to us, my lord.
इसने आगे क्या
এটা সেকশন 5 এটা
देखते हैं
এটা এটা
रिप्लाई दे दिए
সাপ্লিমেন্টারি রিপ্লাই
So section 5 of your limitation act should be taken up for consideration.
That is
And the substitution application,
their contention was that at present keep in abeyance
no,
of this
section 5
5
application is to be taken up upon the substitution application
এইটা এটা
be considered and thereafter the
opposition.
records be corrected.
they intended to keep it kept in abeyance of these other two applications.
No. You see, prior to this section substitution application, how matters can be taken up?
my lord the I am saying my lord
ওই তো ওখানে তিনটাতে দিয়েছ
এইগুলো সব কটা পাস করে উচিত দিয়ে দিয়ে ওকে
চারটা
Yes, which is your application for substitution?
দিয়ে দিও
Because you see, section 5,
my lord I am supplying copy my lord one is of reply another is my lord some mistake has been in the application for dispensing with service upon the respondents as well as on the my lord in the application for exemption of substituting the heirs of some of the legal representatives who some of the respondents who died my lord in the meantime because they have not appeared in the court below as well as my lord we have also some given some their number has been given. I am serving my lord copy to other side my lord that will supplementary affidavit application for an appropriate order.
সার্টিফিকেট দিয়ে দেবো
ক্যান টু তো আগেও দিয়েছেন ওকে
Can do it নয় can do it affidavit in reply. আমাদের কবি জয় আচ্ছা
ওটে ফাইল করে দিন আপনি
I not kindly take up application being can to first. My lord, this is will be can to by virtue of which my lord I have prayed for exemptions of service.
yes, where is this can to?
Can to is with the presenter.
Can to.
Can to.
Can to and they have today supplied the supplementary affidavit to can to.
Supplementary affidavit to can to by virtue of which my lord
Can to what have you prayed for?
the dispensation of service upon this respondent number
Notice of appeal connection with the appeal.
so far as this is concerned my lord
Can to is what?
Can to exempting so far as this is my lord with
regard to which respondents?
2 to 32.
So where have you made that in your prayer? Can to?
My lord, that I have.
They have stated in the preamble portion, and that is I should oppose this because they have said nobody appeared from 2 to 22, but WS are in record, my lord.
No.
They have filed WS.
My lord, from the order sheet, I shall satisfy to your lordship.
They have said never appeared. And I can show, my lord, that they have filed WS.
My lord, from the order sheet, it would appear. that they have not appeared.
What is your prayer?
My lord, for exempting, I attempted to serve.
No,
All the respondents,
you are originally the defendants.
we are originally
I
the
am the
defendant.
plaintiff. I am
How many
opposite party number
defendants you
one.
are representing?
Only one.
My lord, so far as some of the defendants.
No, in the trial court, you represented how many defendants?
Four.
Four defendants.
Four defendants.
Four defendants are the appellants in this
Before
court.
your lord.
Yes, you are for the.
I am for the plaintiff, opposite party number one, respondent number one.
How many plaintiffs were there?
Only one.
Only one plaintiff is
Only
there.
one.
What is the nature? What was the nature of the suit?
Suit for declaration and injunction.
Injunction.
Okay, not partition.
No,
not partition.
They have
They
challenged my title.
That means you sought declaration and
Against
injunction.
them.
Yes, restraining your learned friend's client.
When a trial judge dismissed my plaint, in the appeal, I have succeeded. And
Okay.
they have challenged the.
Now the question is, they are restrained by an order of injunction. So far, the main party plaintiff.
Plaintiff,
plaintiff is served.
Plaintiff has been served.
So let section 5 so far section 5 application is concerned, let the service of other respondents be dispensed with.
That was recorded by the coordinate bench before.
So let section 5 be taken up for consideration.
Yes, 2 to 32, there were some were exempted from service. And some has not been given exempted from service.
Okay, now,
in spite
as
of,
because the main party plaintiff is
Section
before this
5,
court,
my lord, is,
so as
yes,
the main
that
party,
is
let
my
this
lord,
application
which
be
is
taken up,
to
section
exempt.
5.
Yes. My lord, the section 5, my lord, kindly taken up and exemption be given to.
No. So far section 5 is concerned.
Section 5 is concerned.
Others, the
Others,
division
my
bench will
lord,
decide.
by way of supplementary affidavit, I have prayed for such.
Whatever it is, now I am concerned with section 5.
My lord,
The other exemption, whether it is necessary or not, that's a different issue.
My lord, the
Okay, that is
only they have served today the reply. Kindly let them submit. Kindly give me
how
another.
many? This can 1 is section 5.
Can 1 is
How many days delay?
2221 days delay. And only one prescription, one certificate has been submitted before your lordship.
My lord, so far as the delay is concerned, my lord, the delay, the petitioners before your lordships, my lord, they are, my lord, actually illiterate persons and, my lord, having no knowledge about the case filing, and they were dependent upon an advocate. My lord, the appeal was heard in presence of both the sides, and, my lord, the judgment was delivered not at the time when immediately after conclusion of the hearing of the appeal. My lord, we were assured by our advocate that this will be.
So appeal court's order is in which year?
The appeal
2019.
2019.
2019. And the second appeal?
The second appeal has been filed in 2024.
2019.
And my lord,
yes, first appeal in September 2019.
first the appeal was filed before this court in 2024.
Okay, you want some time? I'll keep it next week.
Only not today will be.
Okay, not today.
Then, my lord, kindly make it next week.
Okay, not this week.
Not this week, I said. ওদের সবকটা কপি দিয়েছে তো
আমাকে দুটো কপি দিলেন, একটা
রিপ্লাইটা পেয়েছে তো
রিপ্লাই আর একটা ওই সাপ্লিমেন্টারি। চারটে আপনি ফাইল করলেন, তার মধ্যে দুটো কিন্তু আমি পাইনি।
ও দুটো পেয়েছে করলো, এই দুটো দিয়ে দেন অপোজিট দিস অ্যাপ্লিকেশন।
Yes, you are for?
I am for the plaintiff.
Respondent.
No, I am for the defendant.
Defendant appellant.
Defendant appellant. My lord, the matter was earlier taken up on the 9th of September, and my lord, direction was given that there were certain defects. If we do not cure it within the My lord, period of fortnight. May be dismissed without any further reference. Kindly comes to page 8, my lord. Application.
Yes, page 8 of your petition.
Appropriate order. My application, my lord.
Can 1?
Can 2.
Can 2.
Can 1 is the stay application, my lord.
Can 2. Or the appeal is admitted.
No.
The appeal, there were certain
It is
defects.
What on stage? There's a direction was there.
No, question is if it is not admitted,
It is the recalling of the order passed by the division bench, practically.
how that can
How
be done?
that is precisely the question I am.
No, question is, you see, prior to this admission, how this matter has come. So it can only come if there is a condonation of delay.
No, my lord, there was no delay application.
No delay.
The appeal was filed within.
See, let me see the order. If this order is not complied with, the appeal will stand dismissed. Have you complied this order?
My lord, the
order dated 9/9/2025.
no, I cannot comply with this order. That is
Recording of the same or extension of the time, it is before the honorable division bench.
No. How does, you see, first of all, this appeal has to be admitted.
yes, my lord,
Thereafter,
I get.
it is not yet admitted.
Yes, I follow that. I follow.
So let it be placed before the division bench.
My lord, but I have to withdraw it and file afresh because my lord, for the
So
division bench,
obtain
2
that,
copies.
obtain the leave from the division bench.
Whatever he wants to do.
Yes, record an order. Learned advocates for the parties are present. As this appeal is not yet admitted, this court does not have the determination, and the matter may be placed before the honorable division bench having determination.
Wait for my नाम दिए शुभदा का भी नाम देना
Password is
9.
But not today.
30.
30, not today. 30, you are appealing.
My appeal. Yes. Let him not today.
But not today.
তিরিশে আমি আছি তিরিশে আমি আছি not today কোনটা 31
31 is final. I am for the respondent. And final
31, who is appearing for the appellant?
I'm for the appellant insurer.
one or 2 points about the short matter.
There are 2 issues involved in this case. Actually. Learned tribunal judge, for the death of
The assistant teacher.
Yes.
In school teacher.
For the death of 155-year-old gentleman Miller, learned tribunal awarded 54 lakhs odd. This 54 lakh odd, along with the interest, that is approximately 60 lakhs plus. I have secured before your lordship's court. I have taken 2 grounds in this appeal. One is non-involvement of the vehicle in this accident. The accident took place in the month of February 18.
Yes.
The first written complaint with regard to this accident was made nearly 50 days, 50, days after the accident before the police authorities, wherein the name of the or the number of the offending
49 days.
let him submit, if he starts just jumping
No.
around. They are not aware, they are in High Court. Very unfortunate.
No. Question is, come to this complaint, which page? 10-4?
Page 41 and 42, your lordship will kindly come to of this paper book, Page 40, my lord kindly comes to page 41. Page 41 and 42. I'll also start from 41.
Yes.
This is the first information report.
Yes.
It speaks, that the accident took place, the fourth line from the top on the right.
18/2/2023.
I'm getting to your lordship. 18/2/2023, is the date of accident. The same page, if your lordship kindly says, sixth line in the middle, information received, column 3B, small b, sixth line from the top.
Yes.
Information received, on 8th of April. From 18th of February to 8th of April. If I take both days into consideration, it is 50. If I delete one day, it is 49 days.
Yes.
Why say
কি হলো আবার কি বললে? Lord, if my lord kindly comes to page number 42, next page. Lord, this is the written complaint. This was made by the widow of the deceased. At the bottom, your lordship will kindly see on the right, 8th April 2023. This is what I have indicated in page number 41. My first plea before your lordship, that after 49 or 50 days from the accident, for the first time, this number of the offending vehicle was brought into the picture. Till 49 or 50th day, it was all missing. Nothing on record, nowhere.
And
Neither
this charge sheet was submitted after.
Charge sheet was subsequently submitted. What happens?
18 witnesses in the case.
There was an eyewitnesses. They have brought in total 4 witnesses on behalf of the claimant. There is one eyewitness
in the claim case.
This is a claim case. On behalf of the claimant, there were 4 witnesses. Out of those 4, one is an eyewitness. What happens? After 50 days, the ball starts rolling. Everything is set. Then the charge Caesar would be there. Prior to 50, nothing is there. Everything is in the air. Once the things are arranged, the number of the vehicle is put in. Then the ball starts rolling. Caesar would be there. Owner would come and accept. The charge sheet would be there. Eyewitness would come up from nowhere, from thin air, into the case. Till this day, there was nothing. This is one part. And second part.
Yes.
This was one part, and the second part, was with regard to the quantum of compensation. Deceased was a school teacher. If I invite your lordship, to page number 72.
Yes, 72.
This is the letter of district primary school.
Yes.
And if my lord kindly comes to the next page, page number 73. My lord has seen that, page 73. This is his salary certificate.
Yes.
On the left, your lordship will kindly see,
Yes.
Is earning rupees 53285.
Yes.
Then deductions are there. 6864. Out of these 7 heads, of this deduction, learned tribunal judge has rightly deducted, the 4th one, that is professional tax.
Yes. 200.
So, from 53285, if this 200 is deducted, it comes to 53085.
Yes.
53,085 rupees. The assessment was made on the basis of income of 53,085 into 12. Then the relevant multiplier, the relevant deduction.
Yes.
And the future prospect. My lord, the award of learned tribunal, my lord, is at page 24. My lord, before that, my lord, I'll also show, my lord, page 74 and 75. My lord, 73, my lord, I had shown to your lordship. My lord was kind enough to see that, my lord. This was, my lord, the salary slip for the month of November 2022 at the top. My lord, I am at page 73, if my lord kindly comes.
Yes.
Page 73, my lord, the fourth line from the top, your lordship has seen. This is a salary slip, my lord, for the month of November 22. My lord, page 74 is December 22. And page 75, my lord, is January 23. My lord, no dispute with regard to these. Absolutely correct. Now, my lord, the award passed by the learned tribunal, my lord, in order to avoid any, my lord, confusion, my lord, it starts at, my lord, page number 24. May I invite my lords there, my lord, page 24.
Yes.
Is my lord there? Lord, at page number 24, my lord, as far as the quantum is concerned, my lord, I'll take my lords, my lord, to page number 33, my lord. My lord, I'm now not taking your lordship, my lord, to the nitty-gritties.
Page 33.
Page 33, my lord. That is internal page 10 of the award passed by the learned tribunal. My lord, in the middle of it, income of deceased, paragraph is starting, my lord, in the middle of it, my lord. My lord is there, my lord. I'm grateful to your lordship. Income of deceased is held rupees 53,085. Lord, I had shown your lordship, not page 73, 74, 75.
Yes.
So, on that basis, 53,085 per month. 1/3 is deducted towards personal and so and so. So, my lord, this 53,085 was taken to be the income. Then, my lord, the calculation was made. I'm not on the calculation part. My lord, my difficulty arises, my lord. Like in, my lord, the other case, my lord, on the last, my lord, in the last week when I was arguing, my lord, he is a primary school teacher, or my lord, a school teacher, earning 53,000 rupees per month. My lord, annually, my lord, it is 6 lakhs, 6 lakhs, more than 6 lakhs 36,000, 6 lakhs 37,000. My lord, what is the reason, my lord, they do this subterfuge? I will not very consciously use the term. Why do not you come with clean hands before the court? Where is your payment of income tax? Again, my lord, again and again and again, my lord, you are earning 53,000. Your salary slip would not indicate your income tax unless you get Form 16 or you show your income tax return, because that is yearly. Every single month, salaries, my lord, the income tax is not deducted. My lord, everybody knows that. There is no dispute about that. You are coming before the court. You are asking for just compensation. It is not a lottery or a bonanza, my lord, that somebody dies and you make money out of it. You come with clean hands. Whatever is your entitlement, please take it. Show what your income was. Why don't you show the tax which you gave to the government? This is what my difficulty, my lord, and I keep on troubling your lordship around this score every single time. My lord, today, I will not, my lord, do any further argument if he says that he has got this income tax return or he has got this Form 16. Even today, my lord, accident of 2023, my lord, I will not make any further argument. But you don't come with clean hands and you will start jumping before the court. My lord, I deliberately use this term that no, salary slip is there, salary slip is there. I will pay only professional tax. I'm not entitled to, my lord, liable to pay income tax. I put on this question to myself, why, my lord, again and again, in every single case, you so deliberately choose to not to file income tax return, which you are otherwise liable to. And if you do not, then, my lord, whatever is the prevalent tax rate, your lordship will kindly deduct that. I have made a calculation, my lord. The prevalent tax rate, my lord, for the year 2023, if they still choose, my lord, to not to show the income tax return, my lord, up to 2.5 lakhs, it was nil. From 2.5 lakh to 5 lakhs, it was 5%.
So why didn't you take these points before the trial court?
My lord,
you do not take these points before the trial court.
No, my lord, learned tribunal judge,
whatever it is, you see,
lordship,
your insurance company is not doing the needful before the trial
my
court.
lord,
Only when the award is passed, they come and take this.
No, my lord, learned tribunal judge, my lord, while, my lord, do I need to show to the court below that you follow 14 multiplier?
Your lawyer should take this point.
My lord, yes, my lord, I'm coming to that. My lord, I'm coming to that. My lord, do I need to show to the learned court that, my lord, this tax deduction is mandatory? My lord, learned tribunal judge is taking 53,000. My lord, it is the responsibility of the court.
Why this question is not put in the cross-examination?
My lord,
in the cross-examination, any question put regarding income tax to the employer?
Nothing.
Repeatedly, they are not doing these things, and only in appeal they are coming.
My lord, your lordship, my lord, will.
I'll record these things. These points are not being.
My lord, your lordship will kindly record. Not that these questions whether put in or not put in. But, my lord, while making the calculation, my lord, it's like, my lord, multiplier of 15 or 16 or 17, whatever is the planarity has to be used. My lord, my client, my lord, is not supposed to tell it to the honorable court or learned court, my lord, that in this case, multiplier or 14 or 15 or 16 or 17.
All points are to be agitated.
My lord, this is, my lord, when
several matters are being taken, you see, in several cases, income tax is shown to be deducted from the payslip.
Yes.
In many cases, but because it is the duty of the employer to deduct the tax from source. Tax must be deducted from source.
Employer has deducted, they have not come up with those documents. Your lordship will kindly appreciate. They bring out, my lord, 3 months salary slip. Your lordship will kindly appreciate this.
3 months salary, nothing is there.
Nothing is there. Because in these 3 months it was not there. Then you bring in
all months.
That's my lord, then you bring in 12 months salary slip, it would be there.
So why these points are not put before this thing, trial court?
It should be.
Anyway, next.
Yes. My lord, the learned tribunal court, my lord, the tribunal judgment in terms of the statute itself, my lord has got the inquisitorial capacity. Every single issue, my lord, which is being decided, my lord, court has to decide just compensation. My lord, what is happening? My lord, they are coming before the court. My lord, I'm putting this question. My lord,
court will see the materials on evidence. Why the court will burden his head? Why he is liable to pay?
My lord, may I just indicate what? My lord, we are not in, my lord, adversarial litigation. My lord, I am not fighting with him. Not the only thing what I am saying, what
only
is
just and reasonable compensation.
My lord, just compensation. My lord, every single sentence, my lord, your lordship is, my lord, is thinking of just compensation. My lord, this is what I've learned from your lordship. Now, at least in this, my lord, jurisdiction. My lord, today, my lord is deciding. Let us not put this question to myself. Not what I'm listening. Case of a minor. Admittedly, no earning. My lord is fixing up, my lord, 2,000, 3,000, 4,000, 5,000, 6,000, 7,000. My lord, what argument your lordship is, my lord, expecting, my lord, from the insurance company on this? Insurance company says whatever is just, your lordship will decide.
Yes.
So, my lord, I say he was not earning. He himself says I was not earning. Still, your lordship, my lord, in one of the other cases decided 3,000. Minor's case. In one case, my lord, it was 5,000. Minor's case. Taking, my lord, each individual case on its merit.
Yes.
My lord, why this 3 when there was no income? If I ask this question to myself, why this 5 if there was no income? Because, my lord, the answer is what my lord's mind is thinking, my lord, that the compensation should be just. So, my lord, when there is no admission of income, when there is no admission, there is no cross-examination on income, my lord is deciding the just. My lord, this is what I say. My lord, when the honorable court or learned tribunal is deciding the just, my lord, 1, 2, 3 months salary slip is there. My lord, the mandatory, my lord, deductions of income tax has to be looked into. If he is not liable for paying income tax, my lord, he is not liable. But, my lord, the statute is there, the data is there, it is absolutely clear, you are liable to, you don't come up to the court with clean hands. So, my lord, this refute should not be given to the claimants on this ground. My lord, in any event, my lord, when there is, my lord, violation of policy conditions, no driving license, my lord, I drive, my lord, I have a truck. My lord, hypothetically, my lord, I'm only stating, my lord, how difficult it is for the insurance companies, my lord, nowadays. On a broader aspect, my lord, nearly 50% of the vehicles which are plying on road today in India are not insured. 50, my lord. Your lordship will kindly, my lord, take note of this. It is available on that. My lord, is from,
For example, transport undertakings,
Lordship.
they do not insure the vehicles. Government undertakings,
My lord,
they don't insure.
My lord, they have an option.
Because they take the burden upon themselves.
My lord,
These claim cases.
My lord, in so many, my lord,
In some cases they insure, but in
yes,
some
my
they
lord,
don't.
my lord, the act provides an option.
Yes, they permit it.
To the government that if you want, you take the insurance coverage.
Otherwise, you bear the burden.
Otherwise, you bear the burden. So, my lord, it is government, and my lord, these are only PSUs, public sector undertaking insurance company.
Yes.
My lord, you take out money from one hand and then give it to other. And my lord, it's like that. So, my lord, you don't get it insured. You are the government. You take the burden on yourself. Still, if you want to get it insured it through my lord. And there also, my lord, they have been asked to see to it that they get it done through PSUs. That is a my lord circular issued amongst them. So, my lord, I'm not on that. My lord, what I'm saying, my lord, today in India, 50% of the vehicles which are on road today, my lord, they are not insured. My lord, my learned junior, my lord, is assisting me. On 30th October, Supreme Court has made this observation also. We are talking about 2025, my lord, now.
It is not the duty of the insurance company to see how many vehicles are plying on the
My
road.
lord, we are not the police.
Yes. That is not the duty of the insurance.
My lord, we are not the police. It is for the, my lord, government. Now, my lord, this way or that way, that is the practical scenario. In all these cases, my lord, whatever there are, all these files, my lord, thousands and thousands of cases. In every single case, in every single accident, my lord will find the vehicle is insured. I put this question to myself, how? When every second vehicle in the country is not insured, how come every single accident vehicle, my lord, is insured? My lord,
there are cases where direction is issued upon the vehicle owner, non-insured vehicles. There are awards where vehicle owner is directed.
But how many? 1 in 1,000.
But very rare.
1 in 1,000. 999 vehicles, they find this insurance coverage. I put this question to myself.
There are also matters where vehicle owner is directed. There are also matters before this court.
My lord, there are also matters where the vehicle owner has been directed not for not having the insurance, but for the violation of policy conditions. Insurance coverage is confirmed. How this insurance coverage is confirmed? This is how, my lord, this story is built up in this case. For 49 days after the accident, everything is missing. In between, my lord, the things are chalked out. You will find a vehicle which is insured. You will talk to the owner. You will get an eye. My lord knows this, my lord. I need not, my lord, tell these are the, my lord, very murky grounds. You get an eyewitness. And, my lord, everybody knows this. Supreme Court has come down very heavily, my lord, on these fraud cases, my lord. I'll continue this argument on the next day, and I'll bring those judgments, my lord, where the Supreme Court has said, my lord, I'll indicate that also. My lord, you arrange these things in these 30, 40, 50, 60, 70 days. And then you go and lodge a written complaint by giving the vehicle number. In between, these things have been arranged. You arrange for, my lord, one eyewitness. The eyewitness who saw the accident, who did not inform anything in the hospital, for these days who did not inform anything to the police, all of a sudden, my lord, he appears like my lord Narsingho, and my lord, he comes in the witness box and he said that, yes, at 3 o'clock in the morning, I was there in that field plowing my field. Things are arranged.
Yes, trial court is in a better position to see the demeanor of the witnesses.
Lordship. But, my lord, this is how these things are happening.
We have to go by the record.
That is why, my lord, I said that when 50% of the vehicles in the country are not insured, how come every case wherein the accident cases are being, my lord, are filed, every single vehicle is insured? Because every second case should be without insurance coverage. Vehicle involvement. The lordship is not finding any. My lord has already taken, my lord, at least 100 cases. There is not even one uninsured vehicle. Not even one. The same is with the tribunal as well, my lord. So, my lord, why this is happening and how this is happening? My lord, this is happening to get this award of, my lord, this 60 lakhs. 60 lakhs is not a small amount. It's a huge amount. My lord, people spend their entire lives to earn 60 lakhs. But, my lord, by this management of, my lord, putting in one insured vehicle in an accident, My lord, it was, my lord, I don't say he did not die in an accident. He died in an accident. It was a hit and run case. Or maybe the vehicle which was involved was not insured. So you arrange for a vehicle, you put in that vehicle, and you get, my lord, this advantage of it. And now, not only you are getting advantage of it, my lord, you are going further subterfuge.
That is your argument that the non-involvement of the vehicle.
Yes, my lord, because till 50 days.
That is your ground.
This is one of my ground, my lord.
The other is the income.
Other is the income. My lord, this is, my lord, I was just giving a broader picture to your lordship, not what my lord is dealing with today. When this is the exact, the practical position of the country.
Flying means these vehicles which ought to be insured but not insured. With regard to government undertaking, yes, they are permitted.
Yes, my lord. This is not government undertaking, first, my lord. Government undertaking is correct. I am not on those.
Yes.
They are deemed to be insured by the government.
Yes.
Because Act itself provide those. But my lord, I am on the vehicles which are liable for the insurance coverage, and which Supreme Court says that 50% are not insured. Where are those vehicles? Those are here before your lordship, and those have been implanted in the case, my lord, which were not insured. They were thrown out, and the insured vehicles have been planted in these cases. This is why, my lord, this fraudulent cases. My lord, in fraudulent cases, my lord, Supreme Court, my lord, has given direction to all state governments, my lord, to form SIT, Special Investigation Team. My lord, the direction has been given to the Superintendent of Police, my lord, and to the state as well. My lord, I had filed, my lord, 2 writ applications, my lord, for implementation of Supreme Court order in West Bengal as well for formation of SIT. My lord, in one of those cases, my lord, the state of West Bengal has appeared and has stated that yes, we have formed an SIT. My lord, I made a specific query before, my lord, his lordship, my lord, Justice Rai, Om Narayan Roy, my lord, when the matter was last taken up, that if you have formed a specific, my lord, SIT, that's what you claim, then put it in a portal, put it in a public domain, so that all these fraudulent cases where we apprehend, we means insurance company apprehend that the fraud has taken place, those can be placed before those, my lord. My lord, the learned, my lord, assistant government pleader said, he's taking instructions. It is, my lord, is stuck to that. But they say, they admit, my lord, that SIT has been formed. My lord, referring to these SITs, my lord, in the state of Uttar Pradesh, my lord, only in one financial year, my lord, 2 years after the SIT was formed and the, my lord, matters were referred to the SIT, my lord, claim cases to the valuation of 300 crores were withdrawn or were allowed to be dismissed for default. My lord, lordship will kindly mark the figure 300 crore only in one state of India. Because SIT, my lord, is started taking steps. A number of advocates, my lord, were arrested. A number of touts were arrested, my lord. And whatever, my lord, this, my lord, this irrelevant. Advocate arrest hole irrelevant হয়ে যায়, লজ্জা করে না?
আমি সেটা বলেছি।
My lord,
anyway, you argue with regard to the merits.
My lord, so my lord, these are the 2 main issues, my lord, I have come up for your lordship. My lord, I'm handicapped, my lord, I have not brought, my lord, those judgments of fraudulent cases.
Okay, there are 2 things. That is the income tax issue. The other is the income issue.
My lord,
involvement of the vehicle.
Income issue.
My lord, income, my lord,
and the non-involvement of the vehicle.
Yes, my lord, non-involvement of the vehicle, and my lord, the income part, my lord, wherein, my lord, this deduction, my lord, was not made. Or deduction of income tax. My lord, when my lord is taking note of this, my lord, your lordship, my lord, in case I, my lord, do not succeed in the first point of the implantation of vehicle fraudulent part, then your lordship will be assessing the compensation, my lord. And my lord, in assessment, my lord, they are entitled for just compensation. Whichever way, my lord, this way, that way. So, my lord, just compensation, my lord, you come up with the clean hands, you show this was your income and you take the money. If I lose on the first ground. So, my lord, they say that no. Just because, my lord, this salary slip, particular month's salary slip did not reflect any income tax, my lord, I will not pay. And I was getting a salary of 6.5 lakhs. 6.5 lakhs government salary.
Lordship. Grounds with regard to the non-involvement of the vehicle,
My
delay in the FIR,
lordship,
and the non-deduction of the income.
Non-deduction of income tax. Specifically, my lord, these are, my lord, these are my grounds, my lord. And my lord, if, my lord, your lordship, my lord, wants to see the judgment, my lord, I'll place it tomorrow or the next day, whenever, my lord, please. If it is required. If it is required. If it is required.
No, continue on the next day. If it helps you in this case.
My lord, fraudulent aspect, my lord, I want to show
if
to
it helps you in this case.
But it would help me in this case, my lord. It would
very well
help me in this case also.
On the next day, I shall continue hearing.
No, my lord, kindly allow me.
No, let him complete. Let you learn it from.
No, my lord, he will file the, my lord, some citation, Sheikh Sofiq and Rafiq, whatever thing. My lord, that was, my lord, considered by the, my lord, subsequent judgment of the Supreme Court. That judgments go by
If these decisions of the Honorable
my
Supreme
lord,
Court
kindly allow
helps him, So let him cite those decision on the next day.
Next day, but today kindly allow me to satisfy your lordships the two grounds which are at all justified in his appeal or not. Kindly allow me the 10 to 15 minutes. Now this is a case where undoubtedly the delay in lodging FIR, that the date of accident, the victim who was the assistant teacher who was aged about 54 years, he died, and he was brought to the hospital and declared dead. There are 4 witnesses in support of the claimants. The claimant is the the Bandana Maji, Tapush Kanti Molol. He is the the LDC of district inspector of schools, and one Obijit Ghosh. He was authorized person of district primary school who brought this the salary slips and service books. I will show. And one Shukumar Ghosh. He was eyewitness. He saw the accident, he narrated, and there is no question, no suggestion was there that that vehicle number was not involved in the accident. Now, regarding the the involvement of the vehicles, I will place 3 judgments of this Honorable Apex Courts, and also our High Court follow that judgments. It is a remarkable decision. Robi versus Bodhinar. It was reported in AIR 2011 Supreme Court 1226. Kindly turn to page 6. Page 6. Here the case was dealt with by the Honorable Supreme Court, where there is a number of delays in filing the FIR. Now, I shall read paragraph 20. Kindly see. It is well settled that delay in lodging FIR cannot be ground to doubt the claimant's case. Knowing the Indian conditions as they are, we cannot expect a common man to first rush to the police station immediately after the accident. Human nature and family responsibility occupy the mind of kith and kin to such an extent that they give more importance to get the victim treated rather than to rush to the police station. Under such circumstances, they are not expected to act mechanically with promptitude in lodging FIR with the police. Delay in lodging FIR thus cannot be a ground to deny justice of the victim. In case of delay, the courts are required to examine the evidence with a closer scrutiny, and doing so, it contains so and so. So, my lord, the Robi versus Bodhinan says, my lord, that it is Indian the society. It is not a case that just after death, the family of the disease goes to the police station without performing rituals, the sadhu ceremony. Here no doubt, the accident took place, postmortem was held on the next day. That was reflected in our evidentiary documents, and there was a delay of 50 days. This is my first reliance on the Supreme Court decision. This decision was followed by our High Court, in the division bench presided over the Honorable Justice Dipankar De has his lordship there. It was also reported by your lordship, kindly turn to paragraph 17, page 5. It was reported in National Insurance Company Limited versus Protima Bali, paragraph 17. My lord, here the division bench relying on Robi versus Buddinara. This is also a case, my lord, delay in lodging FIR.
Yes.
My lord, paragraph 17, my lord, their lordships, my lord, holds. In the decision reported in 2011 for SCC, Robi versus Bodhiran, the Supreme Court held the occasion to deal with the aspect as to whether delay in registration of the FIR could be a sufficient ground to ground the claimant's case. It was observed as follows. My lord, quoting from my lord, paragraph 17, 18, 19. It is well settled, but that was told that the claimants, it is well settled. In case of delay, the courts are required to examine and so lodging FIR certainly proves the factor of accident. So the victim, paragraph 19, the victim is liable to lodge a case for compensation, but delay in doing so cannot be a main ground for rejecting the claim. In other words, although the lodging FIR is vital in deciding what delay in lodging the same should not be treated as a fatal for such proceedings if claimant has been able to demonstrate satisfactory and cogent reasons for it. If the claimant has been therefore could be a variety of reasons of genuine case for delay in lodging FIR. My lord, division bench judgments, my lord, following that, my lord, the Robi versus Bodhiran came to conclusion that the points taken that the implantation of the vehicle or delay in lodging FIR. My lord, go ahead. My lord, this is the my lord. Now, my lord, the one thing, my lord, kindly appreciate. My lord, the appeal preferred by the insurance company. Now, my lord, your lordship is about section 170 of the Motor Vehicle Act. Section 170 of the Motor Vehicle Act says, my lord, if the owner, my lord, choose not to contest the case, the insurance company files a petition paying for leave to obtain the malad from the tribunals that they will contest malad the all grounds, including malad involvement, not statutory grounds as laid down in section 149(2). Section 149 confined to driving license, route permit, and malad the insurance coverage. But other than the grounds malad laid down in section 149, the income, the delay in launching, quantum, age, multiplier. If they did not take leave, malad under section 170 of the Motor Vehicle Act from the malad the tribunal, they are malad debarred to malad raise that point. But in this case, malad the instant case which your lordship is adjudicating, the malad the insurance company has taken leave under section 170 of the Motor Vehicle Act. Malad section, even if malad taking leave of 170 of the Motor Vehicle Act, malad they have the right to call for the malad the driver, the owner of the vehicle, whether malad the driver, malad the I will place a one judgment of the division bench presided over Bhaskar Bhattacharya, while in spite of taking leave under section 170 of the Motor Vehicle Act, if the insurance company did not produce the driver and owner of the offending vehicles, my lord, with regard to rash and negligence, with regard to involvement of the my lord, the vehicle in the accidents, my lord cannot raise. My lord, your lordship kindly, that was also reported. Dito, Mita Samanto Jagrata. My lord, kindly see, it was also reported decision. New India Assurance Company versus Mita Samanto. My lord, here the paragraph My lord, your lordship kindly turn to page 5 of that, my lord. My lord, may I permitted to page 5. The paragraph, my lord, 3. My lord, therefore, my lord, may I permit it? Therefore, the insurance company, in spite of taking leave under section 170 of the Act, having failed to summon the owner and driver of the vehicle to disprove the allegations of the claimants of the involvement of the vehicle concerned or the rash and negligent driving, the court is left with no other alternative but to accept the allegation of the claimants, and unless there is either admission of the claimants or their witness about non-involvement of the vehicle or about the contributory negligence of the victim in the accident, or there exists other evidence and an unimpeachable nature given by uninterested witness showing firstly the allegation of the claimants. In this case, there is no such admission of or evidence of that nature. In the case of the driver has been charge sheeted, and thus there is no reason why the insurance company, in spite of taking leave under section 170 of the Motor Vehicle Act, presume should not summon the said driver to give evidence for disclosing the truth. We are unable to presume collision between the driver and the claimant when the driver has been indicated in the criminal proceedings. It will be travesty of justice in the facts of the present case to disbelieve the eyewitness of the claimants when the owner and driver are neither appearing nor they even summoned by the insurer even after taking leave under section 170. So, my lord, this proposition is with regard to, my lord, in spite of taking leave under section 170 of the Motor Vehicle Act, if the insurance company wishes not to produce the driver or owner of the vehicles in a criminal case, my lord, the driver was charge sheeted. Charge sheet was filed. My lord, FIR was lodged, and there was a seizure of the offending vehicles. And my lord, the investigating officers, my lord, after investigations came to conclusion that that offending vehicle driver was, my lord, liable, responsible for the causing accident. So, my lord, in our case, my lord, the insurance company has never challenged the FIR, has never challenged the, my lord, the seizure list, the charge sheet, everything. Go by. My lord, the one legal officers of the, my lord, the company has come. He says, I don't know nothing. I don't know nothing. I do, my lord, know nothing. My lord, if your lordship consider, my lord, even if, my lord, in the written statements, they have, my lord, taken the, my lord, the plea that the, my lord, the income should be assessed as per the, my lord, the requirements of law. But, my lord, what is fallen, I am grateful to your lordship. My lord, they did not, my lord, wish to, my lord, put questions to my clients, my lord. There are 4 witnesses on behalf of the claimants. The my lord, the
Opposite party also adduce evidence.
one evidence, legal officers. If
Insurance company.
Your lordship kindly see what the evidence, my lord, the my lord, OPW1, that is page 21-23. What is outcome from page 21-23? Nothing.
OPW1.
21. Deboshi Bhomi.
Yes.
My lord, he says, my lord, I, Devosi Bhomi, son of so-and-so. I am the legal officer of Cholomandalam so-and-so. That a case under section 1, paragraph 2. 3. Paragraph 4. The income and occupation of the deceased were not paid properly by the petitioner, so it should be treated as notional income. The petitioner could not prove any medical document to show that disease was admitted in Corbetta Hospital immediately after the accident. Malad, this is the Malad. Next page is also the chief that the petitioner does not come before the learned court clean hand, and she has suppressed the original fact. This is the factual aspects, Malad. Now, Malad, cross-examination, what my client's advocates, Malad, says, Malad, if your lordship kindly page 23. Malad, cross-examination comes. Malad, it says, I do not have any personal knowledge about the income and occupation of the disease. Why, Malad, she has come to the Malad court, to the tribunal regarding the income? I have not seen the medical paper of the disease. Malad, I did not file any complaint before the police that the present case has been falsely stated. If the case has been falsely implicated, my lord, the insurance company can, my lord, file a case, my lord, before the legal officers of the company says the company has not filed any complaint before police stations. Investigation has been, my lord, he admitted, investigation report has been submitted by the investigation to our office, but I have not brought the office.
Postmortem report by death.
On the same next day.
No, postmortem reports were all exhibited.
Yes, your lordship kindly.
The inquest report that was also exhibited. Inquest.
No. Postmortem report, your lordship kindly see page 49 to 51. My lord, it is a UD case. My lord, 18.
Oh, he was injured by the RTA.
Yes, road traffic accident. My lord, accident took place on 18 February 2023, and the postmortem report was held on 19 to 2023, just after the the next date. And UD case also referred, and that was, my lord, exhibited. My lord, exhibits, my lord, exhibit 4. That was not challenged. The FIR was not challenged. The charge sheet, my lord, if your lordship kindly turn to page 43 to 46. 46, my lord, the charge sheet case that there are so many, my lord, the witnesses, my lord, the IO has examined. And after one of materials, and he also collected, my lord, some documents. And after considering all, my lord, the evidence and the materials, the investigating officers, my lord, filed the charge sheet against the driver of the offending vehicle. Now, insurance company, my lord, without, my lord, taking, my lord, point, my lord, in the court below, the first time, my lord, before the appellate court says that vehicle was not involved. Even if, my lord, I am placing one another.
Okay, give your compilation on the next day.
Compilation, my lord, I'm giving,
no, give your compilation.
Not 3, 4 judgments I am dealing. My lord, Ashalata. It was decided, in the year 2023, where the Supreme Court says, even if, in the FIR, there is no number of the offending vehicles, but, in the charge sheet, the after investigation was filed, a vehicle, and eyewitness also says that vehicle was involved. The case should not be, dismissed on the basis of the FIR was lost again. That was dealt with, the Ashalata Surjakant Patil versus New India Insurance Company. Now, my lord, regarding the income tax. My lord, your lordship, my lord, kindly remember, my lord, just a few days ago, my lord, that is November 4. my lord, that at that time, November 4th, my lord, the Reliance General Insurance Company versus Niyoti Kumar. My learned friend raised, your lordship, kindly see your own judgment, my lord. Why my lord, my learned friend point that the income আমি দাগিয়েছি আছে দাগি my lord, page 20. Now, my lord, page 20 of your lordship judgments, it is a server copy. Now, with regard to the submission of learned advocate for the appeal and for the respondent number 7, Royal Sundaram, my lord, my learned friend appears, Royal Sundaram. Insurance company limited that income tax return and professional tax of victim is not deducted from income of the victim. This court is of the view that the payslips of the victim for the last salary drawn prior to his death did not show any reflection of the income tax deducted. In absence of reflection of income tax in payslip, this court does not find any error in the part of the learned trial judge to deduct the income tax. This point has been dealt by your lordships. That point was raised, but in every cases, my lord, that my learned friend is agitating. Now, my lord, the assessment, my lord, what the tribunal has said that the pay slips, not only, my lord, one pay slips, series of pay slips. My lord, the accident took place February. My lord, November, December, January, the pay slips. My lord, pay slips, your lordship.
3 pay slips were relied.
Pay slips relied.
Three
pay slips. Why it appears, my lord, that the pay slips does not, my lord, says the income tax deduction. Only professional tax 200 rupees is deducted. My lord, your lordship is award a government service holders. My lord, file form 16. My lord, they could have summoned the the income tax authority or the school authority to submit, or the district primary school authority to produce the form 16. They have never choose to summon that person who says that the sum and substance are the income tax. We are filing the income tax. We file form 16. My lord, I have a documents form 16. I have not, my lord, filed before the tribunal, but for the interest of justice, not. And my learned friend again opposed. Form 16.
I'm saying yes, give it. I'm not opposing. Why tell lies?
No question of any taking evidence.
Taking evidence, because
At this stage,
evidence,
whatever is there is there.
evidence is there, and your lordship dealt with the income tax issue in the Niyoti Kumar judgments. Professional tax is issued, and my lord, the question of involvement of the vehicle, my lord, that was also, my lord, the judgment Robi versus Bodhinan, which was followed by Pratima Barik, and the my lord, the Mita Samanto, that the insurance company did not summon the driver owner on the question of ration negligence and the involvement of the vehicle. That point was considered. Mita Samanto has, by not, followed by the Pratima Barik, and Robi versus Bodhinan also says the lodging FIR does not throughout the claim case. So the award passed by the tribunal is just compensation.
Yes, you reply on the next day.
Yes, Milord. I'll give reply on the next day. Milord, I'll make some arguments, Milord, to the points.
And conclude on the next day.
Lordship.
Yes, learned advocates for the parties have made their submissions. However, learned advocate for the appellant shall submit the reply on 10/12/2025 and file written notes or compilations if possible.
Lordship, before Lordship rising, Lordship, my three appeals have been included in the list without the cross appeal in spite of the direction. I'm
Give
giving
the
the,
slip.
I'm giving the numbers.
Yes, give the slip.
My lord, before rising, my lord, your lordship, money in the list, my lord, 2 p.m. and 3 p.m. two matters.
Yes, yes. Second appeals are there. Yeah, no claim cases will be taken up after 2 p.m.
Lordship.
Oh, bless you.
Lordship, I'm giving the numbers.
I'm
36,
grateful to your
38,
lordship.
41.
Your lordship has patient hearing.
Oh, thank you. Grateful to you.
যা বলছিস সেটাই তো সব মেনে নিচ্ছে
যা বলছি সেটাই নিয়ে নিচ্ছে
বললি মামলা নিও না সেটা নিয়ে নিও।
বাবা কি দেবে যা তো ছেলে বলছে মামলা শেষ করলে আমি ফিস পাবো স্যার বাবা কেন
Next matter, item number 25.
They call the judgments.
Oh. Judgment. Number 1.
Yes. Hence, this appeal fails and the same is dismissed. The judgment and award dated 31st August 2024 passed by the learned additional district judge, First Track Court, Durgapur in MSC case number 1 of 2017 is affirmed.
My lord, the entire amount has been deposited by the insurance company before this honorable court.
Okay, the respondents permitted to withdraw the amount deposited.
Respondent claimants, my lord. Respondent claimants along with interest.
Whatever is there.
My lord.
কি বলছে বললেন তো উইথড্র করতে
Fixed matter taken.
Next matter, item number 5.
लिखने पर ये छोटे बोले थे
application
Yeah,
gulo
please.
find up already jama find up
You are for the respondents.
Respondent, Lord, we have made applications. We are pointing out that the case is covered by the definition of tenant under the West Bengal Land Reforms Act 1990.
No, question is this appeal is ready for hearing?
Yes. Also,
today is fixed for application for 2 applications.
Lord, 2 applications are fixed.
No, one application is for?
One Lord for fixation of the occupation charge.
Oh, occupation charge. That application is pending.
That application is pending.
So how much occupation charge is being paid?
Lord, nothing is paid.
Okay, let me see that application.
Lord, can 7. Lord, can 7.
This is my affidavit in opposition to can 7.
Yes.
একটা can 4
ওরা বলবো ওরা বলবো
Yes, do you want to file your reply to this opposition?
No, not required, Lord.
Yes.
Another application.
What is your opposition?
Can 8 too. Well, just now I have handed over.
Yes.
Opposition din na.
সেটা কি স্যার opposition দেয়া আছে আরে can 8 টা কোথায়
পঞ্চাশ হ্যাঁ
এখন চেয়েছে ওটাই ডিসপোজ করতে তাহলে এটা তো অ্যাপ্লিকেশনটা
সব
my lord another application is can 4 that is also pending that relates to my lord the occupation charges.
No, this can 7 is occupation charges.
My lord kindly see can 4.
Can 4.
Can 4 is my lord it is prayer is
yes Lord, that is same prayer.
Same prayer. How that can be? 2 application on the same point?
Anyway, so one of this application, if
Well,
this
both may be
application-
taken up. Both may be taken up.
No, if it is for the same relief, one has to be taken up. Okay, here you have prayed for the direction upon the judgment debtors to pay the occupational charges of 14,40,000.
Yes.
And in the earlier petition, he prayed for appellant be directed to pay some rupees 13,000 per month.
That is here also.
No, here he has prayed, that is occupation charge from the date of the decree till can continue.
That is the usual prayer.
From the date of the decree.
My lord, that is the usual prayer.
So when the first appeal was pending, was occupation charges paid?
No, at the rate of rupees 50.
As per the
1,500 per month, it was paid according to them till January 2017.
So that was the direction. So the 2017, the appeal was dismissed.
No, appeal was dismissed Lord, on 13th of February 2017.
13th of February 2017.
But prior to that, till January, they paid at the rate of rupees 1,500 per month as directed by the learned appellate court below.
So 2000, that is 1,700.
1,500.
1,500.
Now, my lord, the appeal is pending here and we are entitled to occupation charge from February 2017. And my lord, the area is not posh area, business area.
What is the area? What is the area of the
Mahatma Gandhi Road, my lord?
What is the total area?
60 square, 60 square.
90 square.
60?
16 or 90?
90 square.
90 square feet.
90 square.
Well, sports material shop, lord, is a creative business. Posh area in the Sialda, that MG Road. 69 Mahatma Gandhi Road.
17, তাই তো? প্লেস করুন, তারপর আমরা ক্যান্সেল অপোজিশনটা প্লেস করবো।
So your ground is paragraph 9.
Yes, ma'am.
That is. Yes, how have you, Mr. Mahato, how have we dealt with paragraph number 9?
Yes, my lord, in my affidavit in opposition, so for paragraph number 9, page 5, paragraph 13, I have
Page 5.
page 5 of my opposition,
Yes.
paragraph 13.
Yes.
With regard to statement made in paragraph 9 of the said application under reply, I say that the purported valuation report dated 29 November 2021, prepared by one namely Arpan Dasgupta, chartered valuer, is absolutely baseless, frivolous, and have been prepared at the instance of the applicants. I say that this valuation report is absolutely biased. I say that during the pendency of the instant second appeal, the appellants have also engaged an organization, namely Independent Values and Association, for the purpose of determining the actual quantum of occupation charges which should be lawfully levied upon the appellants. It is relevant to mention here that during preparation of the report, the valuer has considered the status of the suit property as well as the status of the adjacent properties which are also on rent. The valuer has further considered several documents which were obtained from the Kolkata Municipal Corporation in replies to the applications under the Right to Information Act 2005. The rents of several other properties within the same premises in which the suit property exists have transferred from the said replies to the application under the Right to Information Act 2005. It is stated that the valuation report dated 21st of October 2005, prepared by the Independent Valuer Associates, is well explained and extensive report. Copy of such report is annexed, my lord, annexure C. It is at page 13.
Page
13.
13.
ঠিক আছে। কিসে আছে এটা annex করা?
Part of valuation.
Page 31.
Okay, so about 62 square feet.
But it is at
My lord, if your lordships kindly come to page 31.
90.
No,
My lord,
the
if your
area is
lordships,
62 square feet.
my lord, kindly come to page 31 of this application option.
31 of your opposition.
Yes. This is my lord final report at commission what? It was before, when the matter was pending before the trial court, my lord, this was done. Now my lord, relevant page is page 33. The defendant portion at the ground floor. Page 33,
Yes.
room number 3. There are
So you are occupying how many rooms?
one room, my lord.
One room, that is a shop room.
Shop room. And this is the my lord measurement. It has
Anyway, according to your valuer's report, it is 61 something.
my lord. And my lord, the rent should be, my lord, 1200.
At the time of institution of the suit, what was the rent paid?
250.
250.
250.
2000.
And during the pendency of the appeal before the appellate court?
1500.
1500.
Valuer's report is not much less than that.
No, 1500 was as per the appeal code.
Appeal code. And this valuer's report is not showing that 1200 and something per month.
And your valuer's report?
Is not 13,000.
13,000.
It would be because Madam knows your lordship what is the present market rate. Sialda area, Mahatma Gandhi Road.
But I have annexed, my lord, the documents from the
sports
Kolkata
materials are
Corporation.
sold.
Yes, that's true. I am not denying that I am not selling the sports material.
That means, you see, I have to engage another special officer and go inquire from the nearby area, see the measurement, take photographs, and thereafter submit a report.
By the right to Information Act, they have got information from the
Whatever it is,
yes.
let it be done afresh. Then I shall decide the matter. Yes, record and order. Learned advocates for the parties are present. You are for all the respondents.
No, we are for the respondents. All the
hard learned advocates for the parties. This application CAN 7 of 2025 is taken out by the respondents.
But both the application may be disposed of at a time.
Let me consider one way.
But same
taken up for consideration. The respondents applicants have prayed for a direction upon the appellants to pay rupees 14,40,000 from and go on paying monthly occupation charges at the rate of rupees 13,000 per month. This application is contested by the appellants by filing affidavit in opposition. In the affidavit in opposition, the appellants have relied upon the report of the valuer, which shows that the average monthly rent should be 1,200.
1,000, 13,000. No,
how much your valuer has suggested?
1,250.
1,250 rupees. 1,250. Both the appellants and respondents have relied upon the report of the valuer, and the report of the valuer of the appellant suggests rupees 1,250.
13,000 per month.
No, 1,250.
Yes.
And the report of the valuer of the respondents have suggested rupees 13,000 per month. Upon hearing the learned advocate and considering the facts of the case, this court is of the view that a special officer should be appointed to cause inspection of the suit room and take measurements and ascertain the age of the suit premises and the rents of the adjacent area, and thereafter submit report. No, rents of the area.
Area and present market rate of the area.
And thereafter market rate, how he can say? He will inspect, submit a report.
Yes,
whatever is the existing rent in that area. Existing rent in that area. Learned special report to this court. The learned special officers shall upon notice to the parties and the learned advocates cause inspection. The learned special officer may take the help of a surveyor if the parties consent to it. Upon considering the surveyor's report and his own inspection, the learned special officer shall submit a report to this court on or before 8/1/2026. Fix 8/1/2026 for report of the special officer. The remuneration of the special officer shall be borne equally by the parties.
জানুয়ারিতে একটা 6 তারিখ না 8 তারিখ কথা আছে
দিয়ে দেবো ওটা পরে
দেবো বলছে এখন
না নেক্সট আছে 3টের সময় একটু পরে আসছি আমি yes so it will appear on 8/1/2026
at 2 p.m.
for report
at 2 p.m.
8/1/2026 at
remuneration will be
no it should be borne equally by the party.
What is the amount that
I shall fix? That should also be reasonable. You see, everybody wants reasonable. That should also be reasonable.
Two thing I am
8/1/2026 at 2 p.m. At 3 p.m.
One thing, the affidavit in opposition to the application CAN 8. I am filing kindly.
Okay, let the affidavit in opposition file to this application CAN 8
Can I?
We also kept with the record,
And the affidavit of this is also kept.
along with the affidavit of service.
I'm grateful.
ঠিক আছে, 3টের সময়
My lord.
plaintiff respondent.
Yes. Yes, you are for the appellant.
Lordship, I am being led by Mr. Rahul Karmakar. He's on his way, Lordship.
Yeah.
Lordship, if I may kindly take Lordship to the judgment and decree in the original suit, which starts from page 1.
Yes.
Lordship, the issues which were to be decided are at page 5.
Suit was for eviction, recovery of possession.
Lordship.
You are the defendants before the trial court.
Lordship.
So this suit, this decree is confirmed by the appellate court.
Appellate court. Lordship, thereafter my Lordship, from page
What
8.
is the proposition of law formulated? Is to be hard on that point itself.
Lordship.
Notice is
Yes, which page?
is from
Is it there in the paper book?
Page 61. If you logically turn to page 61, subject to question, my lord, this is the substantial question of law which has been formulated. Whether the section 106 of the Transfer Property Act is valid or not. And the issue number 5, probably, my lord, is the issue which required to be considered. Issue number 5 in the...
Yes, only this aspect is to be considered in this appeal.
My lord, can you turn to page 6 of the paper book?
Whether the notice was served, whether
in accordance
with law it is a due service or not.
This is the only consideration.
And whether the learned trial court has considered that or not.
Or appellate, both the courts below.
Yes.
And can you turn to page 6 of the paper book?
Yes.
Issue number 5, probably, my lord, the issue which regards to be adjudicated by these all beings.
So other issues were held in favor of the plaintiff.
All the issues held in favor of the plaintiff.
Okay, and the point of law that is
restricted to this issue.
Issue number 5.
Yes.
Yes.
No, Lordship, the issue number 5 has been dealt with at page 11, Lordship. If I may kindly place, Lordship. This page 11, Lordship has got?
Yes.
Issue number 5. This issue is the most vital issue for deciding the suit. Plaintiff stated that he has sent a notice of eviction through registered post with AD. On perusal of Exhibit 14 objected to, I found that the plaintiff has served a notice dated 23rd July 2006 through his learned advocate, Mr. Vishwanath Roy. Though the defendants have denied the service of notice by stating that their father, Haradan alias Haru Hajra, did not refuse to accept the notice of eviction on 25th July 2006, as the same was not tendered to him by the postal peon. It is further submitted by the defendant that their father, Haradan alias Haru Hajra, was not present in the suit premises, but he has gone to his father-in-law's house and he was still there till Shravan such and such. However, no document has been filed by the defendants to prove the same. On perusal of Exhibit 12 objected to, it appears that the defendant's father, Haradan alias Haru Hajra, refused to accept the said notice and the endorsement on the envelopes was written by the postal peon. Now the question is whether in view of Exhibit 14, it can be said that the notice was properly served upon the defendant. Even if I ignore Exhibit 14, can be perused from Exhibit 11 series to the notice was properly addressed. In the case of Measures Madan and Company versus Wazir Javed Chand, reported in AIR 1989 Supreme Court 630, the Honorable Apex Court has observed that the difficulty where the postman called at the address mentioned was unable to contact the addressee or a person authorized to receive the letter. In these circumstances, postman returned it to the Sadar. Honorable Apex Court also observed that the Indian Post Office rules did not prescribe in detail procedure regarding the delivery of such registered letters. When the postman is unable to deliver it on his first visit, the general practice is that the postman attempts to deliver it on the next 1 or 2 days, also before returning it to the sender. However, he has neither power nor the time to make inquiries regarding the whereabouts of the addressee. He is not expected to detain the letter under the address chooses to return or accept it. The postman is not authorized to affix the letter on the premises because the addressee is absent. His responsibility cannot therefore be equated to those of a process server entrusted with the responsibilities of serving summons of a court under Order 5 of the CPC. The Honorable Apex Court observed that all that a landlord could do is to post a prepaid registered letter acknowledgement due, otherwise containing the tenant's correct address. Once landlord does this and the letter was delivered to the post office, he had no control over it. It is then presumed to have been delivered to the addressee under Section 27 of the General Clauses Act. In the instant truth also, it can be presumed after perusing Exhibit 14 and 11 series that the notice was reached to its destination. I have gone through the copy of the notice, that is Exhibit 14. The notice identifies the defendant's father, Haradhan alias Haru Hajra, as the tenant of the suit premises on the grounds of his eviction, and also properly identifies the suit premises in the schedule of the notice. It also clearly conveys the intention of the landlord to terminate the tenancy. The notice also contains the whereabout thereat to sue in default of compliance the terms of notice. It transpires from Exhibit 9 series and the written statement that the defendant was a monthly tenant under the plaintiff and a monthly rent was settled from the very beginning. Then I think a clear 15 days notice should be valid. However, in a notice under Section 106 of the Transfer of Property Act, one requirement is to be fulfilled that it should give 15 days notice. In the instance suit, the notice was sent on 23rd July 2006 and it has given more than 15 days notice to vacate. So the requirement under Section 106 of Transfer of Property Act is fulfilled, though it is not required to give notice expiring the month of tenancy under the Transfer of Property Act. But plaintiff has given the notice expiring within the month of August, and as such, it can be held that the plaintiff has complied with all the formalities. So I have no hesitation to hold that the notice was legal, valid, and properly served upon the defendant. Thus, the issue number 5 is decided in favor of the plaintiff. This is how issue number 5 has been dealt with. Lord, kindly.
Yes.
নোটিফিকেশন এসছে কোন নোটিফিকেশন এই যে ঠিকা কোন ঠিকা
ঠিকা কোথা থেকে চলে এলো?
অন্য মামলার সঙ্গে মিলে ফেলছে।
হ্যাঁ আসলে এই জন্য বেশি মামলা করলে।
Yes, please.
Now the suit is for eviction on the ground of transfer of property, eviction or expiry of lease upon issuing 106 notice. Now the appeal was admitted on principally on the point that whether the notice was served and notice was legal. The other aspect of the matter that I'll try to argue and impress upon your lordship is that this particular shop room was a manufacturing unit and will not a 15 days notice.
You see, the court has to hear the appeal on the points formulated.
My lord can also formulate a point at the time.
Usually that has to
that be... is I do not think Mr. Roy will not object.
No question of fact, only question of law and
question of fact.
And court has to confine.
Whatever is there in the judgments, my lord, I'll only try to demonstrate that both the courts below, my lord, had committed a wrong in interpreting and implementing the position of law that it should have done. This is my endeavor before your lordship. The first aspect of the matter is, Lord, kindly takes the plaint. They have prepared the paper book, Lord. আমরাও আচ্ছা আমরাই করেছি না এক মিনিট
Yes.
অর্ডার অফ অ্যাডমিশনটা কোথায় আছে
Plain to page 88.
Order of admission. ঠিক আছে, ঠিক আছে, ঠিক আছে.
No, plaint will not be in the paper book, perhaps.
Yes, my lord, it has been annexed. Kindly comes to page 88.
As you know, the scope of second appeal is very limited.
Yes, yes.
And court has to confirm.
I'll not
within the
take
court
your
order.
lordship to my lord the facts or anything finding of facts.
Yes,
Your lordship kindly got it, my lord.
yes.
Kindly comes to page 90.
Yes.
তিন দফা খরিদ মূলে, Lord, it starts from the middle. Your lordship has found it, Lord. তিন দফা
First paragraph.
It's in the first paragraph only. Lord, it's in the middle. Your lordship sees not here. 1, 2, 3, 4, 5, 6, 7, 8.
Yes, yes, yes.
12th line. তিন দফা খরিদ মূলে মোট 15/1/3 ডেসিমাল সম্পত্তির মালিক হয় এবং দত্তের, আচ্ছা, 5 কোটি দত্তের, 5 কোটি কই গেল, 5 কোটি দত্তের ও ওয়ারিশগণের নিকট হইতে পূর্বমতে 5/1.5 ডেসিমাল সম্পত্তি ও তদাস্থাপিত 7 গৃহে, দিস ইজ ভেরি ইম্পর্টেন্ট, গৃহ খরিদ করায় বাদী উক্ত 7 গৃহের 16 আনা রকমের মালিক দখলিকার হয়, such and such. So my lord, the situation was Pachkori, Akhil, Anil, Sushil, Sudhir, they were all compositely, my lord, owner of 16 annas of the property.
Yes.
Out of that, the plain case is, my lord, that Pachkori had constructed, my lord, these 7 rooms.
Yes.
Which, my lord, from the evidence also, your lordship would find, my lord, that was not the situation.
This is
My
a
lord,
question of fact. This is not a substantial question of
I'm
law.
not asking your lordship to get into this. No,
Yes.
these are the facts.
Okay.
But because law can be implemented only on facts. So, my lord, this was the.
Yes, so
Kindly, my lord, comes to page 92,
page
the bottom.
92.
The plain case is that on 24th of July 2006, they had posted a letter.
That is page 92.
92 bottom, last 3 lines.
Yes.
They had issued a 106 notice. 24/7/2006 তারিখে রেজিস্ট্রি ডাকযোগে উইথ এডি নামে প্রেরণ করে এবং রাধাকান্তপুরের পোস্ট অফিসের পোস্টাল পিয়ন বিবাদী সাচ এন্ড সাচ তারিখে তাহার নামিত উক্ত রেজিস্ট্রি এনভেলপ ডেলিভারি দিতে যায় এবং উক্ত রেজিস্ট্রির খাম বিবাদীকে টেন্ডার করে এবং গ্রহণ করিতে বলে, কিন্তু বিবাদী ইচ্ছা করিয়া উচ্ছেদের পোস্টযুক্ত নোটিশ যুক্ত রেজিস্ট্রি খাম গ্রহণ করিতে অস্বীকার করায়। পোস্টাল পিয়ন সংশ্লিষ্ট রেজিস্টার্ড এনভেলপ এর উপর রিফিউজড endorsement on 25th of July 2006. Similar, this is their plain case. Kindly, my lord, comes to my written statement.
Page.
Yes, my lord. Kindly comes to 120, the type copy.
Yes.
Kindly comes to 126.
Yes.
The tenancy right of the defendant on the said property has never been determined or cannot be determined. No notice has been served on the defendant, or no postal peon has tendered any notice under section 106 of the Act to the defendant. The plaintiff, with the postal peon loyal to him, has caused the said notice refused to be made by the peon. So, my lord, there was a specific and categorical denial of this endorsement and receipt. In order to, my lord, demonstrate that the notice was actually, my lord, tendered and refusal had taken place, the only evidence that could have been provided is, my lord, to bring in the peon in the box. Despite this, my lord, despite this statement, nothing of that sort was done. On the contrary, your lordship has seen, my lord, how the trial court has held, presumed. The Honorable Supreme Court says, my lord, this presumption is not possible. When a person denies this service, the owner shifts. That onus has to be discharged. Until and unless that onus is discharged, that statement of refusal cannot hold its truth. Now, my lord, this is one aspect of the matter. Now, my lord, I take your lordship to the impugned judgments.
So paragraph 15 is your allegation.
Yes. Categorical denial.
And whether that
So
issue,
not only allegation. Allegation will come from
yes.
plaintiff.
That is why that issue was also framed.
Yes.
Service was affected or not.
And that is what I'm trying to impress upon your lordship, how that issue should have been decided.
Yes.
There is the perversity. There is the perversity. Lord, kindly comes to the judgment passed by, my lord, the trial court. Page 2 of the paper.
Yes.
Last paragraph. It is pertinent to mention here that this suit had been filed by plaintiff originally against one Haradon such and such. However, during the pendency of this suit, the said Haradon died, and as a consequence, the present defendants have been substituted in his place. Plaintiff's case, my lord, I will not disturb your lordship. Defendant's case also, my lord, I will not disturb your lordship. Yes, my lord, only one thing that I need to indicate is at, my lord, page 4, the last sentence, starting with Bolai Dotto.
Yes.
Lordship, kindly got it. Bolai Dotto, Somorendu Dotto, Gita Rani Dotto, Shobita Roy, and Anita Rani Sarkar for permitting him to construct a house upon the vacant portion of their properties to run a sweetmeat shop. This will be my other limb of submission before lordship. A sweetmeat shop is a manufacturing unit. If it is a manufacturing unit, my lord, the notice for 15 days is, my lord, will be rendered redundant.
So was this plea taken before the trial court?
No, that is exactly, my lord, that is exactly what my case is. The trial court records.
Okay.
This is, my lord, from the trial court's judgment. I am, my lord, reading out from your lordship, for your lordship, my lord. So the trial court was conscious about this fact, and that is the case made out by the plaintiff also.
So
Vacant portion of such and such run a sweetmeat shop. The permitted him to construct a house on condition monthly tenant will not required for your lordship's present consideration. Issues framed, your lordship would find whether the suit is maintainable as per section 106. So, my lord, this issue will also include my argument before your lordship with respect to a manufacturing unit and what is the notice period under 106 for a manufacturing unit.
That issue was framed.
No, this is the issue.
No, regarding was the notice sufficient or not in case
Yes,
of
that is not whether the suit is maintainable as per law, as per 106. That is the issue.
And your case is this, the notice itself that is not sufficient.
My submission before your lordship
So
is
if
on
your
two
case
aspects.
is, you see, you have received the period mentioned in the notice is not sufficient, that is one thing. If you have not itself received the notice, then cause of action does not arise.
So, Lord, I have twofold submissions before your lordship. One, that the notice was never tendered to me. The question of refusal will take a backseat because it was not tendered to me. That's my first limb of submission. My second limb of submission is assuming but not admitting that the notice was not served upon me. Even then, the notice was insufficient. The period mentioned in 106, the mandate of 106 was not complied with.
Your original lease was with regard to what purpose? That is purpose to.
The purpose is for running a shop room.
Running a shop room.
Yes.
Okay. Just simply shop room or some manufacturing purpose?
Nothing was indicated.
Just shop room.
Just a shop room.
That
And
means
I
not
was utilizing that property for
to construct and make a shop
I
room.
say that the property was constructed by me. I say that the property was constructed by that shop suit premises was constructed by me. That's a disputed question.
For running a shop.
Yes, I am not getting
Okay,
into
assuming notice was served, it is not sufficient.
Yes. Because manufacturing unit for manufacturing unit.
Whether that was a manufacturing unit.
That is exactly what
No,
I
your case, but what evidence did you adduce to show? No, question.
Whether a sweetmeat shop, existence of sweetmeat shop not disputed.
Okay.
Existence of sweetmeat shop not disputed. If not the sweetmeat shop's existence was disputed, then the question of it's a disputed cannot be assailed in a second appeal could have come. So sweetmeat shop existence is admitted. Now, my lord, what I am trying to impress upon your lordship is, if sweetmeat shop was admitted, then sweetmeat shop, how it is to be interpreted?
No, whether this point was argued before the trial court.
Lord, this is a point of law.
No. You see, interpretation of law. You see, the two courts, whether you argued these two points there or not before the two courts. Anyway.
Lord, even if I have not argued before the two courts, Lord, I'll make this submission before your lordship, and I'll demonstrate with support of by sub judgments also that a point of law, even in second appeal, my lord can scrutinize. If it is a point of law, my lord is hearing my appeal only on point of law, substantial question of law.
That the point
Nothing
which
more
is
than
formulated is purely a substantial question of law.
The two courts.
Now, whatever you are. Yes. This is the thing.
The two courts completely ignored this aspect. This is the perversity. The two courts completely ignored this aspect. This is the perversity. Now, my lord, kindly comes to page 9. Rather, my lord, comes from page 8.
Page 8.
So, issue number 1, my lord, I had indicated to your lordship. This is issue number 1 and 2.
Yes.
It is evident from the plain and written statement that the dispute between the parties are civil in nature and the suit premises lies within the jurisdiction of Dashpur PS, which is within the jurisdiction of this court. When the suit was filed on such and such, the suit is also not bad for misjoinder or non-joinder of parties. I further find that the suit was filed within the period of limitation. Cause of action of the suit as stated by the plaintiff arose on such and such, and the suit was instituted on such and such. According to the plaintiff, the defendants have failed to quit and vacate the suit premises within the specified time, even after receiving the notice to quit. Defendants are defaulter in payment of rent, and now plaintiff reasonably requires the suit premises. On the other hand, the defendant stated that their father, the original defendant, requested the previous owner, Bolai such and such, to construct a house upon vacant portion of their properties to run a sweetmeat shop. They permitted him to construct a house on condition that he would possess such and such premises as a monthly tenant under them at a monthly rent of rupees. They further state that they did not deflate the payment of rent. Therefore, so far as the case made out by the plaintiff and the relief sought for, this court is of the opinion that this suit is well within the eye of law and the plaintiff has sufficient cause of action to file the suit. The issues are therefore decided in. Lord, nothing, no observation with respect to why a sweetmeat shop should not be considered as a manufacturing unit, and the rigors of 106 will not come into play. Now, my lord, kindly turns over to page 6 again. Issue number 5. Whether a notice of eviction is served upon the defendant, if so, was it valid, legal and sufficient? So this is again issue number 5. Kindly, my lord, turns over to page number 11.
It was 234. Calcutta.
Issue number 5. The issue is the most vital issue for deciding the suit. Plaintiff stated that he has sent a notice of eviction through registered post with AD. On perusal of exhibit 14, such and such, I find that the plaintiff has served a notice dated such and such through the learned advocate such and such. Though the defendants have denied the service of notice by stating that their father Haradhan such and such did not refuse to accept the notice of eviction on that date, as the same was not tendered to him by the postal peon. It is further submitted by the defendant that their father Haradhan Hajra was not present in the suit premises, but he had gone to his father-in-law's house and he was there till Shravan. However, no document has been filed by the defendants to prove the same. Lord, the onus was upon the plaintiff. The trial court proceeds on the basis that as if I have to prove my case. It is first the discharge has to be done. The onus has to be discharged by the plaintiff. Then it shifts upon me. On perusal of exhibit 12, it appears that the defendant's father Haradhan Haru Hajra refused to accept the said notice, and endorsement of envelope as refused was written by the postal peon. Now the question is whether exhibit 14, it can be said that the notice was properly served upon the defendant. Even if I ignore this is exhibit 14, such and such, exhibit 11 series, that the notice was properly addressed. In the case of such and such, has observed that difficulty where the postman called at the address mentioned and was unable to contact the addressee or a person authorized to receive the letter. In these circumstances, postman returned it to the Sodor. Honorable Apex Court also observed that the Indian Post Office rules did not prescribe in detail procedure regarding the delivery of such registered letters. When the postman is unable to deliver it on his first visit, the general practice is that the postman attempts to deliver it on the next 1 or 2 days, also before returning it to the sender. However, he has neither power nor the time to make inquiries regarding the whereabouts of the addressee. He is not expected to detain the letter until the addressee chooses to return it or accept it. The postman is not authorized to affix the letter on the addressee's absence. His responsibility cannot therefore be equated to those of the process server entrusted with the responsibilities of serving summons of a court under Order 5. Lord, kindly seize the departure in the manner in which, as if the answer is known and calculation is being made so that we reach to that answer. The Honorable Apex Court observed all that a landlord could do is post a prepaid registered letter such and such, otherwise containing the tenant's correct address. Once landlord does this and the letter was delivered to the post office, he had no control over it. It is then presumed to have been delivered to the addressee under section 27 of the General Clauses Act. In the instant suit also, it can be presumed after perusing exhibit 14 and 11 series that the notice was reached to its destination. I have gone through that copy of the notice. The notice identifies the defendant's father as the tenant of the suit premises, the grounds for his eviction, and also properly identifies the suit premises. It also clearly conveys the intention of the landlord to terminate the tenancy. The notice also contains the threat to sue in default of compliance the terms of notice. It transpires from Exhibit 9 series and written statement that defendant was a monthly tenant under the plaintiff and a monthly rent was settled from the very beginning. Then I think a clear 15 days notice should be valid. However, in a notice under section 106 of the Transfer of Property Act, one requirement is to be fulfilled that it should give 15 days notice. In the instant suit, the notice was sent on such and such, and it was given more than 15 days notice to vacate. Lord, again a presumption. No discussion why, my lord, that issue of Lord sweetmeat shop, manufacturing unit, nothing. So the requirement under section 106 of the Transfer of Property is fulfilled. Though it is not required to give notice expiring the month of tenancy under the Transfer of Property Act, but the plaintiff was given the notice expiring with the month of August, and as such it can be held that the plaintiff has complied with all the formalities. So I have no hesitation to hold that the notice was legal, valid, properly, and thus issue number 5 decided in favor of it. Not completely a cryptical order, as if the notice is valid because it has been refused. The issue, Lord, that I had categorically denied in my written statement, the onus has shifted. It was upon the plaintiff to prove and demonstrate that yes, it was tendered. No discussion. The issue when the court observes and records that it's a sweetmeat shop, Lord, there is no observation as regards to why it shall not be construed as a manufacturing unit. No discussion, nothing. As if he finds that it has been refused, now you have to go out of this property. Now, my lord, this was the trial court judgment. Kindly, my lord, comes to the appeal court judgment. আমার কি মানে দু কোট হারা বলে আমাকে শুনবেও না জজ সাহেব? লাগবে, দেখাতে হবে। কেউ তো কিছু দেখেইনি, সেগুলো দেখাতে হবে না? না, my lord, দেখেইনি।
Yes, page.
Kindly comes to page 31. These were the points of determination before the appeal court. Again, whether the learned trial court had erred in holding that the notice of ejectment was valid, legal, and sufficient and had been properly served. So, my lord, validity and service both were under scrutiny. Learned trial court had erred in not considering that the tenancy of the defendant in such suit was permanent. I'm not addressing your lordship on this. Kindly comes to, my lord,
Yes.
Turns over to page 32. Point number 1.
Yes.
The point number 1 has been framed upon the question as to whether the trial court had erred in holding that the notice of ejectment was valid, legal, and sufficient and had been properly served. I firstly took into the grounds as to sufficiency of the notice and service thereof. Learned advocate for the appellants had asserted that the notice is an incomplete one as it does not state about termination of the tenancy. Learned advocate for the appellant submitted the language of such and such is not proper, and for which such notice be construed as being a notice effective enough to terminate the tenancy. Section 106 of the Transfer of Property Act only states about the period prior to termination, and that such notice must be in writing, signed by or on behalf of the person giving it. The mode in which such notice is to be tendered and delivered. The language of section 106 do not state that the notice must be in any predetermined and prescribed format. A notice shall be deemed sufficient if it unfolds the intent behind such notice and conveys such intent unequivocally to the person addressed in clear terms. On perusal of Exhibit 14, it appears that the notice states in clear terms that the tenant was to hand over possession of the tenanted room on such and such, and from such date the tenant shall be regarded as a trespasser in respect of such room. Therefore, the very reason for which such notice was being served has been stated through the words in clear terms. On perusal of the impugned judgment, it appears that the learned such and such had scrutinized the content of the notice.
Now you see one thing, termination comes when? Prior to the completion of the period on particular grounds, tenancy or lease is terminated.
Absolutely.
After the normal period, whatever it is, or as per provided under the law, that word termination need not be used. Simply stated. What is the requirement under the law? Ingredients that has to be.
The only
So
thing
that termination is the penal clause actually.
only that's exactly I'm trying to
Because
indicate
you
to
see,
you.
the moment you terminate means what? Prior to the completion of a period, you terminate.
Absolutely. Well, that's exactly what I'm on. Now, termination under 106 are two folds.
Yes.
One 15 days, one 6 months. Similar, that has to be clear. I cannot terminate an agricultural lease for a 15 days notice.
No.
Or 1 month notice giving a
Termination,
15 days time.
That termination must be according whether
in accordance with 106.
Yes, whether the lessor is permitted to terminate or not. If law does permits him to terminate, he can terminate in accordance with the law.
Precisely that is the point.
Yes.
So my point before your lordship is the lease which could not have been terminated prior to that time as per the rigors of 106, if it has been done, is bad in law. এখানেও রান্না হচ্ছে ম্যানুফ্যাকচারিং
দেখাচ্ছি
দেখেছো?
Yes.
On perusal of exhibit, it appears that the notice states in clear terms that the tenant was to hand over possession of the tenanted room such and such, and from such date the tenant shall be regarded as trespasser. This part I have indicated to your lordship. Lord. Kindly takes the trouble, my lord, to travel to the middle, my lord, starting with the learned trial court. Your lordship had kindly got it, my lord? In the bottom of that page.
Yes.
Page 33. The learned trial court.
33.
Page 33.
33.
I'm on 33. The learned court had also correctly held that the statutory time period as required to be given to the tenant was actually given by the plaintiff through the said notice. This is the other fault. Therefore, I do hold that such and such has rightly, not whatever.
No,
hence
your lease was for a particular period. Oh.
It's a monthly tenancy.
Oh, it's a monthly tenant.
Monthly tenancy.
That means,
terminable
that
upon
means,
issuance of
yes, that means lease of month to month.
Yes. Whether it is a month to month or year to year.
No, what is
what
the case of the plaintiff? It is a month to month.
The plaintiff says it's a month to month tenancy.
So you have admitted that it is month to month. What is your contention?
My contention is I run a sweetmeat shop.
Maybe whatever you run. What is
the sweetmeat shop? It is a manufacturing unit.
No, question is whether you are admitting your lease to be a monthly lease. What is your contention regarding that first averment?
Lord, I have indicated to your lordship in the recording of the judgment.
First paragraph is your lease was from month to month.
Yes. That's the plain case.
Monthly tenancy.
Monthly tenancy.
No, monthly tenancy. That means
month.
Lease is for month to month. Month to month. So what is your stand in the written statement? Is it month to month or per a particular period?
The tenancy tenure of the tenancy. Subject to correction, the argument my learned friend wants to advance that it can be done by 15 days.
No. First, forget about that. First of all, what is the case of the plaintiff?
Is
It is the lease of month to month.
Month to month.
Plaintiff is month to month.
Month to month. What is the case of the defendant?
The case of the defendant, I have shown your lordship recorded in the order.
No. In your written statement, what is the case? It is not month to month. Have you expressly denied that?
Lord, I have stated that I carry out a sweetmeat shop.
No, question is, have you expressly denied that? It is not month to month. Then you see the question of law comes.
Very well. I'll take your lordship to that.
An agreement was there originally. No agreement was there.
No agreement was there.
So monthly rent used to pay.
Yes. And that is the evidence which I adduced, monthly rent receipts.
Lord, in the written statement, a case of permanent tenancy was made out. A case of permanent tenancy was made out. So effectively, I had denied Lord that month-to-month tenancy. Effectively, I have denied that month-to-month tenancy. Kindly, Milord, comes to Milord, the type copy, page 122. The statement made in item number 4 of the plaint, major portion of the statement is not true. As stated in the plaint that Panchkori Dotto had made 7 rooms and by inducting temporary tenants, he realized rent and was in possession of all those are not true. The said room was constructed by Panchkori Dotto. All he has not inducted temporary tenant. Out of the said room, the room under possession of the defendant was constructed by the defendant and he has been in possession of the same. The tenancy of the defendant has become permanent. The plaintiff is bound to prove the said person.
If it is become
so
permanent
I
under
on proof.
No. Under what provisions you have claimed this permanent tenancy?
Not permanent tenancy.
Then that is another question of law. Under what provision of law?
I'll not trouble your lordship with that.
Permanent tenancy. You see, you are paying rent from month to month.
I'll make my submission. I'll mold my submission in a manner that once I say it is a permanent tenancy, I deny that it's a monthly tenancy. I'll stop at that, and that had to be related to Milord the existence of a sweetmeat shop.
The question is,
kindly Milord relates the situation like this.
No, I have to relate
Milord,
what
these
is
are
there in the record.
court draftings, Milord. Your lordship knows our honorable Supreme Court has said, Milord, Mufassil draftings cannot, Milord, should not be
drafted by the lower court's advocate.
Mednipur.
Yes.
Very well, very good in civil law.
Yes, Milord, but should not be taken on the face of it.
Interpretation. There are very stalwart lawyers.
There is a doctrine of election subject to correction.
Now the question is, you see, whatever is your case, you have to develop that.
See that I have denied monthly tenancy by saying that it's a permanent tenancy, and accompanied with that, I have said that I run a sweetmeat shop.
So
the only tenancy
what is the evidence? What is the evidence that you have run a sweetmeat shop?
Case.
The question is, you have to prove. Your
nature of induction.
Proof,
nature of induction. That is the main proof for the purpose of.
He is paying rent month to month. Now, from month to month, you are being paying. There is no written lease.
So month to month.
Month to month lease or month to month tenancy.
Yes.
And 106 will apply. So, where is the case that 106 is not applicable?
Very well. Lord, kindly comes to 106 once then.
ট্রান্সফার অফ প্রপার্টি একটা দেখুন তো আছে কিনা এখানে
কিছু দরকার নেই paragraph 18 of the written statement
paragraph
18 of the written statement page 116
116,
Yes.
paragraph 18. Transfer of property আছে এখানে? ওই দিকটা দেখুন তাহলে। Yes, paragraph 18.
Yes.
Yes. Yes, which provision you want to rely? Transfer of property.
Yes,
Last
Lord, kindly
106.
comes to 106. Going.
উক্ত দাগের উপর প্রায় 40 বছর পূর্বে লাস্ট 4 লাইনস
Yes.
পূর্বে অধীন মিষ্টির দোকান করিবার জন্য উক্ত সমাদার দত্ত নিকট হইতে অনুমতি প্রার্থনা করিলে উক্ত সমাদার দিকে তদ্বনে উক্ত খালি ভূমির উপর অবস্থিত প্রস্তুত করিয়া লইতে প্রাণাতে ভাড়াটি হিসেবে দখল করিতে থাকিতে পারিবে।
Grateful. That
Very
takes
well.
care of my case.
Yes.
No,
So it is
nothing else I need to indicate.
now sweetmeat shop comes with the permit of manufacturing in terms of
Yes.
Transfer of Property Act. That is I have to
Nothing
prove.
more than that I
Very
need to indicate.
106.
Yes.
In the absence of a contract or local law, a lease of immovable property for agricultural or manufacturing purpose.
Whether it is monthly or yearly, the interpretation of 106 will indicate. In absence of a contract or local law or usage to the contrary, a lease of immovable property for agriculture or manufacturing purpose shall be deemed to be a lease from year to year. So, my lord, whether I have said, not said, everything takes a back seat.
On your basis
I
of
have
saying
considered
that it is a sweetmeat shop and
Manufacturing.
comes under section 106, and these are the documents that it is a sweetmeat shop, and this is a manufacturing unit under the law.
Lord,
I am
have-
protected.
I have, Lord, indicated to your lordship. I have read out, Lord, the trial court judgment. Your lordship has
Whatever
not
you said,
found a
if
single-
that no, what you said, the trial court has considered
But I
that.
have read it out for your lordship. I did not say. I have read it out for your lordship.
Well, there should be an express pleadings that yes, it is for this manufacturing purpose. It is
So
for
that is
sweetmeat shop.
exactly my learned senior friend read out for your lordship. Just now, para 18 of my
মিষ্টির
written
দোকান
statement.
করিবার জন্য
What is that?
মিষ্টির দোকান।
Mishti Dokan.
That was clearly category held by the honorable this honorable court 1954 Calcutta. It was held.
Sweet shop, no, is sweet shop comes under
No,
manufacturing.
I'll deal with that. I'll deal with
Sweet shop comes under shops and establishments.
Lord,
At best.
I'll
That is said, it is a commercial purpose without manufacturing. The character of sweetmeat shop is nothing but a commercial character without manufacturing.
Not a meat.
Lord, what
Not
is
meat.
what is manufacturing?
Yes,
That has to be seen. What is manufacturing?
Under which definition?
I'll indicate.
Yes.
I'll
If your case comes, definitely you are
Yes.
protected.
Lord, it has nothing to do with meat. Lord, it's nothing
Only
to
sweet.
do with meat.
Sweet.
So there is
Sweet.
a heavenly difference between a
What
sweet
is-
shop and a meat shop.
Lord, what is a manufacturing? Manufacturing is when the original product is processed in a manner that the originality is lost. That is manufacturing. If I qualify within that, then, my lord, my purpose is served.
No, where did we get what evidence is there that it is a manufacturing shop in the documents?
There are two kinds of sweetmeat shop. One is I take ready-made sweets and sell it off.
Yes.
That is one.
And the other is
one
preparation.
I prepare it in my in-house.
Where is that
and sell it.
evidence? So
I'll tell your lordship. That those were not gone into.
anyway, you
Those
see
were not gone into.
whether
That
there was
exactly what I want.
the question is whether there was necessity to go into. If you give
Yes.
specific case,
Under
it
the
can be
law,
gone
there is a
into.
necessity. Under the law, there is a
No,
necessity.
if unless you give a specific case, how the court will go into?
Specific case, it is.
Nothing, no
para
particulars.
18.
It's devoid of particulars.
Lord, para 18 is the
Nothing,
specific
nothing.
case.
From that,
Acha, very
that is
good.
not a good ground to get a relief from the
Lord,
court.
then I'll take your lordship to our Kolkata Municipal Corporation. How sweetmeat is being treated here. How sweetmeat shop is being treated here.
And that is a panchayat area.
106.
Lord, the principles will apply. Lord, only because it's a panchayat area, the principle on which this sweetmeat shop is treated in corporation. that does not
Anyway, you just, all these things you cover under your written notes.
Acha. Yes, I'll do that. I'll do that. Arekta copy করতে নোটটা দিতে Yes. Lord, my lord has a Kolkata Municipal Corporation Act. Lord.
Anyway, if you have there, you read it out.
Yes. Lord, under Schedule 5, serial number 23,
Yes.
Roman Milord 55. Roman sub-rule 55. 23 starts as manufacturing, parching, packing, pressing, cleaning, cleansing, boiling, melting.
Okay, Schedule
Such and
5,
such,
serial number
etc.
23.
Whatever
What is manufacturing is?
Manufacturing, parching, packing, pressing, whatever is there, whatever any of the following articles. And 55 under that head is sweetmeat and confectionery goods. Now, my lord kindly takes the definition of manufacturing. But this is for my lord. And this is for my learned senior friend.
Black dictionary, naki?
Yes.
So this is the 6th edition of the Black's Law Dictionary.
Yes, yes.
Lord kindly turns over to the first page, the last entry, my lord, on the right hand side.
Yes.
Manufacture. From the Latin words manus and facture, literally put together by hand. Now it means the process of making products by hand, machinery, or other automated means. Kindly turns over. Facture means defined as making of goods or wares by manual labor or by machinery, especially on a large scale, has expanded as workmanship and art have advanced, so that now nearly all artificial products of the human history, such and such, nearly all such materials as to acquired changed conditions or new and specific combinations, whether from the direct action of human hand or chemical process devised and directed by human skill or by employment of machinery, are commonly designated as manufacture. The process or operation of making goods or materials produced by hand or machinery, anything raw materials, from raw materials by hand machinery, the production of articles for use from raw materials or prepared materials by giving such materials new forms, qualities, properties, or combinations, whether by hand or labor. Manufacturer, one who by labor, art, or skill transactions raw materials into some kind of finished product, not which ultimately will which not have any resemblance with the raw material. So, my lord, when I produce my sweetmeat in my own in-house, I run a kitchen. Lord, in that kind of a scenario, Lord, it has to be treated as a manufacturing unit.
So, for example, in a restaurant, suppose food is prepared and served.
Food is prepared and served. Lord, under it's the food is a raw material. It has to be treated in
Maybe
that
you see here it is sweet. Sometimes it may be food prepared in the kitchen of the restaurant, and then prepared food is served. So whether that will also come.
Eviction of a tenant, monthly tenant from the house is not permissible according to my land. 6 months notice. Kitchen, meat will come. Now it will be treated.
Not for a second saying, my lord, that it is not possible, but it has to be as per 106.
So 6 months time ought to have been given.
As per 106.
So whether your plea was 6 months notice, this 15 days notice is not sufficient as per the law.
Yes.
And in the event, it should be
6 months.
6 months notice and not 15 days. So is that there in the paragraph 18?
Paragraph 18, Lord?
Yes. That it is a sweetmeat shop and this 6 months notice ought to have
Manufacturing
My
unit, my lord.
case was
sweetmeat.
Manufacturing unit, not only sweetmeat, manufacturing unit.
It is a sweetmeat manufacturing unit and 6 months notice is mandatory.
Yes.
Where is that pleading?
Lord, the plea is that there is a sweetmeat shop that I
No,
operate.
there should be a
Lord,
specific plea.
if I operate a
Where
sweetmeat
is that?
shop,
Where is that pleading? Paragraph 18.
paragraph 18 kindly comes to 116.
Paragraph 18, yes, 116.
40 বছর পূর্বে অধীন মিষ্টির দোকান করিবার জন্য উক্ত সমরেন্দ্রনাথ দত্ত অনুমতি প্রদান করিলে উক্ত সমরেন্দ্র দত্তর দিগের তৎক্ষণাৎ সাচেনসাচ উক্ত খালি জমির উপর অধীন গৃহ প্রস্তুত করিয়া লইলে তাহাতে ভাড়াটিয়া হিসেবে দখল করিতে অনুমোদন প্রাপ্ত হয়। এইরূপ প্রস্তাবে অধীন বিবাদীর সহিত তৎকালীন মালিক সমরেন্দ্র সাচেনসাচ thereafter I want to proceed.
You see, the court appreciates the position in what is possible in case of residential unit, that is not possible in manufacturing unit to comply within 15 days. So statutory period is there, okay? Or agricultural unit.
Yes.
Whether your case was this is a manufacturing unit, so this notice is not sufficient.
If I can demonstrate before your lordship that I
Now,
was
what is the
operating.
scope in second appeal to all demonstrate all these things?
No, this is there on record.
It ought to have been that 6 months notice has to be given. This is a manufacturing unit and I get the protection of the manufacturing unit. The entire notice is not
By
sufficient.
operation law, I'm entitled
Nothing,
to.
you see, devoid of particulars, your awareness.
Particulars is required in case of where, my lord,
Because you see, you two cases, the notice is not served. The other is notice is bad, void, and the other is insufficient.
Yes.
So this insufficient, this protection is available to you when you say that this is a manufacturing unit and 106, 6 months notice is necessary. So that notice is not sufficient. So entire thing will go. So where is that pleading?
Lord, even if I don't plead, if under the law I am entitled to.
So the court is in the dark. What type of unit is this? It is
No,
just the court. The court cannot presume here in second appeal.
The court had to do that. Both the courts below had to interpret that, my lord, a sweetmeat shop to be whether a manufacturing unit or not.
Where will the court presume? No court
But the
can presume.
particulars only required was whether it is a sweetmeat shop or not. If from the sweetmeat shop I can demonstrate, not that was the situation. The matter
if you want a specific relief, you have to
kindly
particulars.
Not I'll indicate a judgment on this.
Yes. So with regard to manufacturing unit, very well show that.
কত বলছি বসো kindly, my lord, 46. This is, my lord, AIR 1946 Calcutta 317. Division bench judgment. 317.
Paragraph?
বলছি দাঁড়াও।
Yes.
হ্যাঁ নিশ্চয়ই।
Yes, when was the suit instituted? Which year?
Suit was, my lord, instituted 2006.
20 years, near about 20 years.
2006.
Sweetmeat is going on.
May I please sit, my lord?
Yes.
This appeal is on behalf of the defendant in a suit commenced by the plaintiffs for recovery of possession of the land and building described in the schedule of to the plaint on the allegation that the defendants are thika tenants whose tenancy is determined by a notice to quit. The only question that was canvassed in the courts below relates to sufficiency of notice that was served upon the defendants by the plaintiffs' landlords. The defendant's contention was that as the lease was taken for manufacturing purpose within the meaning of 106, the lease must be deemed to be year to year and a 6 months notice was necessary in terms of that section. The plaintiffs, on the other hand, contended that the lease was a monthly lease and hence terminable by 15 days notice expiring within the month of tenancy. Admittedly, the defendants carry on hosiery business in disputed premises under the name and style Jayanti Hosiery. It is found by both the courts below that the defendants carry on part of their manufacturing business in another premises where sheets or yarn are prepared from raw materials, and on the premises in dispute there are knitting and cutting machines where the sheets are worked up into articles of hosiery and made ready for the market. The sole controversy centers around the point as to whether these facts, which are admitted and found, it can be said that the lease of the premises in question was taken for manufacturing purposes. Having heard the learned advocate both sides, we are of the opinion that the view taken by the Court of Appeal below is wrong. The learned subordinate judge seems to be of the opinion that as the raw materials are not worked up into hosiery articles in the disputed premises, it cannot be said to be lease was taken for manufacturing purposes, as was calling from your lordship. Even though the knitting and cutting were done in that building, we do not think that we can accept this view as sound. To manufacture, according to the dictionary, means to work up materials into forms suitable for use. The word material does not necessarily mean the original raw material, for finished article may have to go through several manufacturing processes before it is fit and made ready for the market. What is itself a manufactured commodity may constitute a material for working it up into a different product. Thus, for example, for the tanner, the material would be the raw hide, but the leather itself, a manufactured article, would constitute the material for the shoemaker. So, my lord, what the court says here is what is the finished product might not be a finished marketable product. Here is a case where I will not gather milk and other raw materials and prepare a sweet. So, my lord, it changes the raw materials entity. That's why it's manufacturing. Do not work on raw hides. So far as the hosiery manufacture is concerned, undoubtedly articles have to be made from raw cotton as it is picked from the bush. From the cotton, certain yarn or sheets are prepared and they are knitted into hosiery goods. It is immaterial that the yarn is not produced in the premises in suit. It is enough to make the house a manufacturing house if knitting and cutting operations are gone through this premises, and that is an essential part of the manufacturing business. Same is the case as my learned senior friend was indicating. Ami shingara banai.
Yes.
So then this could not have been the judgment.
What is the distinction between you see, there is a distinction between food processing industry, food processing house, and a shop.
I have shown to your lordship, that's why I had indicated the corporation's rules. The Kolkata Municipal Corporation identifies a sweetmeat shop under the manufacturing category. It identifies that. Now, to clarify that cloud, I had indicated Kolkata Municipal Corporation rules. Lord, kindly see for once.
Yeah, roasted will be.
Yes. Lord, kindly cease.
What is the difference before this judgment when learned friend relies upon? Lord, kindly consider what is the defense taken.
No, whatever is that, I will consider that.
Kindly see, Lord. 23. My defense is clear and simple. Sweetmeat shop.
Notice.
Sweetmeat shop. My defense, categorical defense. Sweetmeat shop. I stop there. Nothing more is required.
That is 20.
23.
23.
23 and takes the trouble to turn over the page and come to Roman 55. You know,
Lordship leave 5 minutes.
Yes.
Just come.
The Lordship has kindly
Which
seen.
page? 311, 300?
Lord kindly comes to serial
31.
number 23, Your Lordship seen?
Yes, yes.
23.
23.
The heading Your Lordship has seen,
Yes,
manufacturing.
yes, manufacturing.
Now kindly turns over the page and comes to serial number Roman 55 LV on the left hand side. On the left hand side of the book. Lordship has seen sweetmeat,
Yes.
sweetmeat and confectionery. Similarly, the corporation classifies the sweetmeat to be a manufacturing unit. That is exactly what I'm trying to impress upon your Lordship. It's very easy to say, সিঙ্গাড়া বানাচ্ছি কালকে আমার ম্যানুফ্যাকচারিং হয়ে যাবে, আমাকে বের করতে পারবে। It's not like that. If there is a law, one has to adhere to the law. I have not taken a point of limitation. Now I cannot take that point. Lord, can it be sustainable? It is the court's duty. It was the court's duty to find out whether the suit was by limitation or not.
Why do you invite the court to come to?
But I have invited.
By adducing sufficient evidence.
Invited the court by saying that this is a sweetmeat shop and a list of exhibit কোথায় আছে আমার সার্টিফিকেট অফ এনডিসমেন্ট ওগুলো দেওয়া হয়েছিল না
Yes. So anyway,
yes,
you have relied upon this provision.
Yes. Now, Lord, I'll take your Lordship to one more situation. Grants me Lord 1 minute's time. So this is one aspect of the matter. Kindly, Lord, also 82 Supreme Court. সার্টিফিকেট অফ ইনভেস্টমেন্ট ওগুলো দেওয়া থাকে ম্যানুফ্যাকচারিং মানে সুইটমেট শপ হিসেবে This is not 1982 one Supreme Court cases 27.
Yes.
On legs বল ওটাকে টাইম করা Let us kindly got it, Lord. Paragraph 10. Coming now to the tests laid down by this court, the position may be summarized as follows. That it must be proved that a certain commodity was produced that the process of production must involve their labor or machinery. Now, this is on when a product can be said to be, or a shop can be said to be operating as a manufacturing unit. That the end product which comes into existence after the manufacturing process is complete should have a different name and should be put through a different use. In other words, the commodity should be so transformed so as to lose this original character. Milk, sugar, both are transformed to lose its original character, not relatable to their original character. So this is what the purpose of manufacturing, the word manufacturing is in 106. So only because to get a easy remedy, a certain segment has to be thrown out, now that cannot be done. But the judgment that my learned senior friend is going to cite, 54 Calcutta, I understand. Lord, that judgment does not take into consideration all these aspects. That judgment simpliciter says that it's a small room, so that's why no manufacturing. Manufacturing has to be large scale. But from all these judgments I have indicated to your lordship, will your lordship find a place where this magnanimity of this manufacturing unit has to be this big has been said? No. Supreme Court has also clarified, and long back, not the Black Law Dictionary, the definition was already there. So, none of the courts below has not taken this into consideration. It was the court's duty to find out and interpret. When I have specifically taken that point that I am using a sweetmeat shop, and nobody has denied that. The courts record it. The courts
Just
observe
1 minute.
it.
Yes, what is the page number?
My lord.
Schedule?
Schedule 5 of Kolkata Municipal Corporation, my lord.
5.
Schedule 5 under section 435, if I am not mistaken.
Yes.
My lord has kindly
23.
Schedule 5, serial number 23, sub serial number, my lord, 55. The legislature recognizes it. Record থেকে বার করো, রেকর্ডই তো আছে। Can I have the lower court records once? Lord, your lordship wanted to see.
Yes, yes.
Lord, I'll just indicate it to that. একটু এলসিআরটা দাও না। ওই লিস্ট অফ এক্সিবিটের ওই জায়গাটা থাক, তুমি পুরোটাই দাও দেখি।
Yes, I have gone through that schedule. Now, any other decisions?
Yes, yes. Lord, এই এটা একটু খুঁজ করে চলে গেল। Now, Lord, Lord, this is my submission with respect to that this is a manufacturing unit. And Lord, both the trial courts have perversely and failed to consider the aspect of the sweetmeat shop to be a manufacturing unit, and for that a 6 months notice at least ought to have been. Now, my lord, my next line of submission with your lordship is, my lord, on service. Both the courts below have gone on the line that under section 27, only because it was posted to a correct address, not the onus was discharged. So now I had to prove that I did not refuse or of that evidence. I had to submit. No, that is not what the law says. In case of tenancies, Lord, section 27's presumption is qualified. Once I say I rebut, it's a rebuttable presumption. Once I rebut by specific statement that I have not received, it's negative. Negative cannot be proved. The onus shifts. Then the plaintiff has to come and prove by bringing in the postal peon. No endeavor taken, no endeavor made. And the trial courts proceeds on that basis.
Sure. Are you sure?
What? Postal to pain. Postal.
Yes, can you conclude today?
Lord, I'll take some more time, Lord.
So conclude on the next day, and
very good. I'll conclude on this.
And if you want, you can submit your written notes also, or thereafter.
On the next day, Lord, I'll conclude and submit my written notes.
Next day also conclude and submit.
Conclude and submit your written.
Yes.
Acha, next week you see, because last 2 weeks this bench will not sit.
That is next week any time which is Constable Lordship, I'll come and I'll distinguish the judgment which is there and I'll rely upon one judgment. দেখিস আমি বললাম কত টাকা?
দুটোর সময় কবে ফাঁকা আছে?
হ্যাঁ বললাম বলতো পোস্টমাস্টার এসেছিল পিয়ন ছিল না, তাই জন্য যে পিয়ন ছিল পোস্টাল অথরিটি পোস্টমাস্টার এসেছিল।
ঠিক আছে, এটা দেখেছি। তাই তুমি বললে এত শিওর করে পোস্টাল পিয়ন আসেনি দেখেছি।
দুটোই
চল
তাহলে দুটোই দিয়ে দেবো।
না এগুলো আমার না,
অরিজিনাল সাইডে অরিজিনাল সাইড Advocates, let this matter appear on 10/12/2025 at 12 p.m.
Well, I'm sure Mr. Roy will take only 10 minutes his time.
Yes, and come ready with your written notes and compilation of decisions.
Yes. If he wants to cite any more judgment, at least
No, come with compilation.
Yes,
It should be easy.
I'll indicate that.
So I can also give answer to those. Huh? Okay.
আমার বইটা একটু দেবেন না, রসগোল্লা তৈরি আছে। রসগোল্লা